directed them to file within 2 weeks. They have chosen to file it now.
We have served them on the last.
This application is the affidavit of service, nothing else.
Can is for what?
No, it is this.
What is it? Service.
Oh, early listing.
With me, boss. Yeah, for early listing, my lord. Nothing else.
Yes.
Anyways,
So, my lord, I want
I have the copy.
file your report.
I have been blacklisted for 5 years. 2 years of that blacklisting period has already expired. Kindly give me 7 days to file an objection to the report and
लिखे नहीं. खबरदार लिखे नहीं. Report.
Lord, if you'll give me a little bit indulgence, there's a little bit of urgency. Lord, I'm unable to open my video. Lord, the problem is, Lord, the bank will take possession on the 29th. And I wasn't able to mention at the time of mentioning because the VC was not on. There's extreme urgency, my lord, if your lordship takes it any time today, my lord.
What matter is there, Mr.
Section 14, my lord, Aniruddha Chatterjee, my lord. Section 14 has been allowed. We've gone to the DRT, my lord, but the DRT can't take up the matter, my lord, because of paucity of time. So I am helpless, my lord, but to come before your lordship. Kindly takes it up.
Because of paucity of time.
Yes, my lord, it's there. That is the order verbally. It's there in the list, cannot take up because paucity of time. I can't go anywhere else apart from coming to your lordship.
Clear. Serve notice on the bank, but
Yes,
there's
Lord.
nobody here to hand up the slip or
Yes, Lord, there is. Mr. Devjit Mukherjee is there.
No, nobody is there.
Lord,
Nobody.
I'll make sure right now he goes there. Right now. I'll make sure. Lord, he's on his way. He's on his way. He's just outside the court. He's getting inside.
Yes, but the bank.
Whenever your lordship pleases. Whenever.
Bank has to be put on notice.
I will do that, Lord. I will take care of that.
Very good.
What time do I come back, Lord? May I ask this question to myself, Lord? 12 o'clock or 1 o'clock?
Before 12 o'clock, you'll be able to serve the bank.
I think so, Lord. By mail, it can be done.
Mail, I don't think it will be proper. Because
I'll do it, but keep it at 2, Lord. 2.
2 p.m. 2.
Very well. So grateful, Lord. Extremely grateful.
I'm for WBSC. This matter has been kept for dismissal. On the last occasion, nobody appeared.
लिखे नहीं. None appears for the petitioner.
For the respondents. Same thing on last occasions also they didn't turn up. 5th August.
कोई सेम ऑर्डर হবে শুধু 4/8 এর জায়গায় 5/8 করবে আগে. আচ্ছা তার সঙ্গে লিখে দিন what is can 1 for. What is can 1?
Yes, there somebody file an application for addition of party.
Since WPA 8220 of 2026 stands dismissed, comma, can 1 of 20. Next,
I think in the meantime they have settled. It's absolutely a private dispute.
next.
I am for the WBC decision.
ওই সেম অর্ডার 5/8 আগেরটা সেম অর্ডার ডিসমিস করে দিন. নেক্সট.
My lord, I am for the petitioner.
I pay for the respondent, madam.
কেস লিখে নিন. লিখে নিন. This writ petition has been 6 লিখে নিন 6 এর সেম অর্ডার হবে ওই ডিসমিস ফর ডিফল্ট 18/8 হ্যাঁ নেক্সট সেম অর্ডার 18/8 yes
Milord, it is my affidavit of service in item 8, Milord. Milord, I am a tenant, Milord. Milord, page number 21 is my tenancy agreement. And Milord, Alipur judges section court has granted injunction to my eviction, and I also moved before the honorable dear team, Milord. But after hearing of this matter, the church court DRT 2 has reserved the said order for more than 1 month. Milord, in this circumstances, as per the order of the learned Chief Judicial Magistrate of Alipur, I will be evicted, Milord. Milord, the possession notice and the order is in page 34, Milord. And the said reserve ordered by Honorable DRT is page 38, Milord. Contention of the essay application is that he has been the rightful tenant. On the other hand, the learned counsel of the dependent submit that mortgage was.
who is appearing for the bank what are your instructions madam are you going to take possession during pendency of the order reservation by the DRT
We cannot take the
Yes, Milord. It's page number 39, Milord.
then
Milord, quite a few things, Milord.
Milord, every day police is coming.
they are
Milord-
not going to take possession how can police come
No, first-
unnecessarily this
No, firstly, Milord, I appear for this. Firstly, this is a report that has been given to me.
Milord, a report may be given to me.
Now, look, kindly seize the prayer, Milord. Quite a few things. The landlord, there is a proceeding before the DRT that's pending. He has gone before a civil court and taken appropriate orders. So there is a civil court covered, there is the DRT who is proceeding so far as the loan is concerned. And now he is coming to
Milord,
this court under the electricity determination.
no.
And this is,
surface determination not
oh, I'm sorry, no, there is also invoked electricity, I believe.
No. How?
আমার ব্রিফটা কোথায় এটা তোমার ব্রিফ আমাকে ব্রিফটা দাও
কি বলছেন?
no this is surface not electricity
well kindly
Milord, in this circumstance, if any protection is not,
that is the top sheet.
maybe but I also
He's
have
made a
surface
mistake.
determination it
There are several mistakes in this. In one place is some other name is there. Anyways, well, kindly comes to the prayer, madam. Yes, somewhere some Ranjit
where
Mollik
is
has
the
come.
plaint?
Look, page 17 is
Where
the
is your
prayer.
plaint?
yes, Milord.
Plaint.
Milord, my plaint is in page number 40, Milord.
Declaration and injunction. Prayer is in the plaint at page 45.
So in the plaint, the bank is also party.
Yes, Milord.
Then how are you saying that they are going to take possession?
Milord, the police is telling that we'll take the
Are
possession.
you going to take possession unnecessarily?
No,
how
no,
can
no.
you take possession if the bank is not?
No,
Don't
no,
take
unless
unnecessary-
the bank order,
Why
what is the question? Now
order
there
may
is a
be
civil
passed
suit.
until
not pass any order. I dismiss this with
until the DRT pass the final
I
order.
will dismiss this with cost. You have an injunction, you want an injunction from the High
Yes.
Court.
No,
What
Milord.
kind of a writ petition is this?
Milord, as per their view, civil court order is not valid in SARFAESI Act.
This writ petition has been filed Reading for the petitioner. Challenge to 13. None appeal
Sufficient
for the
proceeding.
petitioner. No accommodation is prayed for. List this matter under the heading for dismissal on Monday, 31st. Next.
On Monday.
One must make sure. Lordship, I am for the petition. Lordship applied for a domestic connection, Lordship. I have annexed the rain receipt, Lordship. CSC authority held the inspection. Thereafter, they have issued the later dated, Lordship. That is the annexure P2, page 12. Kindly see, Lordship. That after the inspection, we have referred the matter to our commercial department for further investigation, and its completion, we will apprise you further. Thereafter, petitioner visited the office of the CSC authority. The CSC authority handed over 2 bills, Lordship. One in the name of Janab Abdul Wahab and one in the name of Janab Jahangir. And the Lordship kindly sees both the bills once. Annexure P3, page 13.
Yes.
Lordship, CSC authorities handed over these 2 bills in order to clear the outstanding dues in respect of both these consumers. But the address in the said bills are 71 by H by 7, Dr. Sudhir Bose Road. And petitioner is the tenant. Different premises, Lordship, and these 2 persons, and they are demanding 78,000 in total from petitioner.
I've just talked to them. Kindly grant us opportunity to file a report before your lordship. Lordship kindly gives us 10 days time because there is some holidays are there, so that the matter can be resolved. So that the inspection can be made and further report can be filed. And lordship kindly fix up the date and time.
Lordship.
So may I come back with a concrete report?
Lordship,
before-
only prayer is this: when the matter will be returnable, it is returnable in a new motion. Entire building, there are 2.
The petitioner complains
I directly appeal for the respondent bank only. But this is
My-
a calling application.
Appearing to the page.
What is this?
This is the
Restoration
affidavit of
application,
service.
Matter got dismissed in 2025.
What is affidavit of service?
Affidavit of service. My lord, on that day I personally fell ill. I am the advocate on record.
The restoration is
immediate-
concerned, I have had no objection. Lordship
Grateful.
kindly consider the main
4
matter.
days, 4 days after the.
No, I'm not opposing restoration application, but their section 17 application is pending before the DRT for final adjudication. May I hand over the order? Whatever
Okay,
they have
what do you
paid
want
before
in
your
this?
lordship, my lord, they have paid the
All
same
are
thing.
pending, my lord.
Petition on
During-
merit.
Yes, my lord.
On merits, what is your argument? Merits.
Merits. Yes, my lord. My lord, actually, during pendency, before issuance of 13-2 notice, this matter was litigated before the commercial court Asansol. There, the money suit number 19 of 2021, that is within the petition. And thereafter, they have preferred original application before the DRT, challenging.
What have you challenged here?
My lord, for restoration and there within the pendency of these litigations, not one litigation, many litigations, the DM Bakuda has issued notice and they are we represented.
Challenge it before the DRT.
My lord, we have represented before the DM.
Very good.
Without considering anything, they have passed the order.
DM is not
And
not
challenging
authorized to
that-
consider.
The
DM
bank
is
has
not
also
authorized to
filed-
consider.
The
My
bank
lord,
has
If
also-
DM had considered the representation
Yes.
and they had come, I would have set aside the section 14 order. Please go through the judgments of the Honorable Supreme Court. DM is not the adjudicating authority.
My
It has
lord.
ministerial role to play. So your representation non-consideration does not give teeth to your writ petition.
my
Anything
lord.
else?
No, my lord.
The bank has also filed a writ petition by seeking implementation of the district magistrate order. The police is not cooperating with us.
Can 1 of 2025 is an application for restoration of the writ petition which was dismissed for default on October 24, 2025. Full stop. Paragraph. In view of the good ground shown in the application for restoration, the order dated October 24, 2025 is recalled and the writ petition is restored to file. Full stop. Paragraph. ওটা কেন লিখবেন এই অর্ডারটা নিচে চলে আসুন the
with NOC. Not this week. Lordship, I have only this instruction for not this week. We will file section 5. That's why.
For the contempt.
Lord, I have to do my 30 minutes break to appear for the petition.
My lord, as per my instruction, they have complied with your lordship's order.
Lord, it is my submission and your lordship was earlier recorded also. This is the matter when the notice was served, notice was not delivered to the petitioner number 1, and your lordship categorically last order recorded that even in the petitioner number 2, no notice has been, hearing of the notice has been served. And they have taken an ex parte order, and your lordship was directed.
My lord, kindly have a look. My lord, both of them has been served. Petitioner number 1 has been
Right.
served on 18th, and petitioner number 2 has been served, but it has returned with the endorsement that insufficient address.
No, my lord, your lordship kindly see, I have filed the supplementary affidavit.
Supplementary, my lord, I don't have a copy.
But it was the notice dated 13th August, perhaps. Supplementary affidavit wrong. It was posted on 18th. Date of hearing fixed on 21st. At that point of time, my petitioner number 1 was not in home. The number 2, the notice was addressed to the petitioner number 1. It is the recording of your lordship in last order. The notice was addressed to the petitioner number 1. Even last occasion, the earlier advocate has appeared, he could not able to produce the notice upon the petitioner number 2. But what is we are only want to fruitful hearing of your lordship, direction of your lordship. Even no fruitful hearing has been given. What is the purpose of passing the order by a constitutional court?
My lord, as the petitioner was not present at the time of hearing as such. My lord, then if your lordship, my lord, then we can. My lord, then. My lord, then kindly grant us some time. We shall give another notice and give another hearing, my lord. My lord, but only the later notice issued to the petitioner number 2 has not been annexed with this application. I have been told that it has been it is returned with
But
the
in-
endorsement insufficient address. I can
But-
produce that. Not that means not served.
Even this, your lordship see the conduct of the respondent. Yes, I want hearing.
Well, then kindly grant us 3 weeks time. In the meantime, we shall serve another
Your
notice.
lordship may kindly fix date from your lordship court.
My lord, at this time, my lord, we will serve the notice upon
Well,
the advocate on record of the
Yes.
petitioner, my lord.
Yes.
Yes, ma'am.
same matter.
14, my lord, I am for the applicant. This is the affidavit of service, my lord.
My lord, in this matter, my lord, we intimated the authority for report, my lord. We are praying 2 weeks time for report.
My lord, since 2025, my lord, the petitioner contender
as
is
per
not.
Lordship's direction, my lord, we are appearing, my lord, in this matter, my lord, and we have duly intimated to the authority, my lord. We are praying only 2 weeks time.
No, my lord, sir. They has received the
The
same.
same.
my lord.
Very well. Likhe nin.
Yeah.
Mr. Bandopadhyay.
My lord, same contender, same application, applicant, my lord.
Article 15.
15.
My lord, we have served a notice. The meeting for revision of timetable is fixed on 31st of this month, my lord.
No notice has been served till now, my lord.
I have got instructions that the meeting will be held on 31st of August.
That is on Monday.
Monday. My lord, kindly keep the matter pending. It will be.
Likhe nin. Affidavit of service filed in court today.
My lord, in this matter, I appear on behalf of the state, my lord. I've just been orally instructed to appear on behalf of the state, my lord. I've not been served with a copy of the petition as yet. My lord, I was seeking an accommodation of a week, my lord, to take instructions. And I am told that the order passed by your lordship has been duly complied with. So let me come up with a report to that effect, my lord. Gives me a 1 week time, my lord.
The direction was that to comply the order of the division bench by issuing a notification jointly by the State Transport Authority West Bengal and State Transport Authority Jharkhand. We have not been given even a notice. No notification has been issued. And that can be done jointly by two state transport authorities. I don't know how possibly my learned friend has not been properly instructed. It cannot be
I'll
complied.
take instructions, my lord. I just received
Take
an oral
instruction,
instruction,
come
my
back.
lord.
Thank you. এটা আমি করে দিচ্ছি করে দেবো।
And for the petitioner, my lord, as per the last order dated, I have been served the copy of the contempt application to the contemptor, my lord. This is my affidavit on service, but till date, it is not complied with, my lord, the order.
You have no instruction, my lord, I will take instruction of the authority.
What is your instruction? Not complied with?
Not I have no instruction, my lord. As the state is not appearing, my lord, I undertake to take instruction from the authority. Along with
Affidavit of service filed in court to
Lordship.
18th. Yes, next.
May it please Lordship, Lord, I'm led by Mr. Mukherjee, Lord, on Lordship.
Yes, sir.
Mr. Banerjee will address your lordship.
May it please Lordship. Now, my Lord, this is a writ petition in which, my Lord, pursuant to my application, my Lord, an offer was made, my Lord, for grant of a Salt Lake property, my Lord, of 3 kathas against payment of a certain amount of premium. I had made payment of the amount, total amount, my lord, as had been demanded. There was no timeline fixed for completion, my lord, on the part of the state. State itself said that they would be developing and doing other things, as I'll take your lordship, my lord, through the document in the meantime, and they took the entire money from me. According to me, a concluded contract was entered into. Subsequently, my lord, this is not my wife. My wife, my lord, subsequently, she passed away. And thereafter, even during the time that she was living, no field of choice was offered. As in, 3 kathas was mentioned in Salt Lake, but the government was under an obligation, therefore, my lord, to give a field of choice as to which were the 3 katha plot of land which was supposed to be taken by us. That was, my lord, not offered by the government, and admittedly so. Later on, my lord, a question was asked as to whether, during the wife's lifetime, as to whether a commercial entity, Ajanta Shoes, had any connection, my lord, with the wife. Because otherwise, whether she was using it for using the plot, she would be using the plot for commercial purposes or residential purposes. That was clarified, my lord, to the government, and the government, it was said that that Ajanta venture is a different venture, which is a commercial venture that has nothing to do with the present allotment. After that being done, now, my lord, without allotting, my lord, the plot in question and going forward, my lord, to make the lease, subsequently, my lord, suddenly in the year 2009, this is cancelled. My lord, if your lordship kindly sees, my lord, the order of cancellation at page 45. I'll come back, my lord. Yes, page 45, my lord, of your lordship's brief. My lord, if your lordship kindly sees, 18th March 2009, whereas a plot of land measuring about 3 kathas was allotted in favor of Srimati Bithika Bonik, that's, my lord, the wife of the petitioner number 1, under this department order number such and such, dated 19th of April 1989. I'll take your lordship, my lord, to that order. And whereas Srimati Bithika Bonik was requested by the said EE Design SLR and D Circle to choose a plot at Salt Lake on 4th September 1989 and on 25th April 1991. And whereas Srimati Bithika Bonik has not approached to this department to choose a plot of land at Salt Lake within the scheduled offered dates. And whereas Srimati Bithika Bonik, through her letter dated 31st of July 2006, had requested this department to complete the pending formalities of the for selection of the plot and to complete execution and registration of lease deed. And whereas it appears that on the prayer of Bithika Bonik for condonation of delay for choice of plot and other formalities, including execution and registration of lease deed, is without any justifiable grounds for the lapse of more than 17 years from the date of offer letter, that is 19th April 1989. And whereas it appears that she has failed to fulfill the terms and conditions of the offer letter, number 343 SL, and has failed to take delivery of possession within the scheduled period, the offer of allotment stands cancelled and determined in terms of the offer letter. Refund of salami after deduction of 50 rupees as administrative charges will be considered on submission of prayer with all requisite documents by Srimati Bithika Bonik. Now, my lord, it is my duty, my lord, to show your lordship, my lord, the original offer that was made 19th of April 1989. Please come to me, lord, page 35 of my lord's brief.
Page 35.
Page 35. This is an offer which, according to me, we accepted, giving rise to an executory contract. Lord, may I place, Lord, it's in the name of Srimati Bithika Bonik, coming, Lord, from the Assistant Secretary of the Government of West Bengal. Madam, with reference to your application for allotment of a plot of land in Salt Lake City extension scheme under this government, I am directed by the order of the Governor of West Bengal to state that a plot measuring about 3 kathas more or less in sector 1/2/3 of Bidhannagar, Salt Lake Township may be demised to you on lease for 999 years, subject to the following terms and conditions. A. The plot will be available on lease for 999 years on payment of a premium or salami charged at the average rate of rupees 6,000 rupees 6,000 only per katha, provided, however, that you will have to pay the extra charges for locational advantages, if any. The additional charges for locational advantages are corner plot, open space, shop allowable, etc. There's milord an increment given milord in terms of percentage. B, you are given option to deposit salami in one of the following ways: payment of full amount of the said salami or premium calculated provisionally at the said rate in one installment within 90 days from the date of this letter. Balance salami as may be finally calculated on the basis of the actual measurement of the plot and the location of the plot after selection of the same within 90 days from the date of demand, failing which interest at the rate of 7% per annum will be charged for first 2 years and 10% for the third year. Your Lordship kindly notices here, my Lord, there's an interest payment clause, which means that time is not of the essence here insofar as payment is concerned. Second, because, my Lord, they said that actual salami will only be recognized after the plot has been allotted, so that the locational advantages and all can be factored in. So this is something, a part of the executory contract, which is left unperformed, which will be done after the allotment is actually made by the government. Now, my Lord, reading on B, Roman 2, payment of 50% of the said salami within 90 days from the date of allotment, and the balance of the salami calculated on the basis aforesaid with interest at the rate of 7% if the payment is made within the first 2 years, and interest at the rate of 10% for the third year with effect from the 91st day from the date of issue of this letter. If you fail to make payment of the balance sum even within 3 years from the date of issue of this letter, the allotment will stand cancelled and the salami already paid by you will be refunded after deduction therefrom administrative charges of rupees 50. Please go back to the letter of cancellation. My Lord recalls this is, my Lord, one of the grounds that has been cited here, that the offer stands cancelled. Now, my Lord, the next page.
Offer was made in sector 1, 2, and 3.
The
All
offer was,
sectors.
my Lord, as I have shown you, Lordship, it is sector 1/2/3, which means a 3 katha plot has been offered to me on 999 years basis, subject to payment of salami as sought here. The field of choice has not been narrowed down to a particular plot, your Lordship has found. So that there's a contract that it will be given to me. This contract which is there, therefore presupposes that I will be given a field of choice which I will be required to exercise. If not exercisable, like the West Bengal Estates Acquisition Law Act cases, if you have a right of retention, you don't file your B form in time, then the government gives you a plot which you have to take. But if your Lordship goes through the purport of this entire offer, my Lord will find that there is no question of the offer being considered, my Lord, to be an inchoate offer even after I've accepted it. It becomes an executory contract. My Lord, kindly see, my Lord, just see, after C, my Lord, kindly see D. Salami or part thereof will be deposited with the Reserve Bank of India, so and so, under the head so and so. Other housing schemes, Salt Lake, reclamation schemes, receipted challan will have to be deposited in an executive engineer design. After the salami in full and all other dues as deposited, you will have to enter into an agreement with the government, accepting all the terms and conditions of the lease in the form sent to you separately. Checks or cash money towards payment of the salami or part thereof will not be accepted. All payments to be made by depositing in the RBI. Now, my Lord, F. On failure to make payment of salami within the prescribed time limit mentioned above, the allotment shall stand cancelled and the government will be at liberty to offer the plot to another party. This is, my Lord, one of the default clauses. The plot of land will be used exclusively for residential purpose and for no other purpose. Taxes or other impositions, if any levied by the government, will be paid. Now, my Lord, kindly see I, this is important. No assurance of completion of development work by any specified date or the manner of such development will be given. So, my Lord, they will develop the area and give it, but no assurance is given as to any specified date. Now, my Lord, kindly see J is important. Physical possession of the plot will not be handed over before the premium or salami has been paid in full in time and the lease deed executed and registered. No assurance of delivery or possession of the plot to be selected by you by a specified date after execution of lease deed is given. That means whatever I select may not be the final plot which I get. Before that, physical possession will be handed over after the premium or salami has been paid in full. Now, my Lord, with this, my Lord, kindly, my Lord, reads clause A of the previous page, the premium or salami is 6,000 rupees per katha, which is 18,000, plus there might be additional charges in connection with the situs of the plot. So if it's a corner plot, 10% more. If it has open spaces on 3 sides, 15% more, and the like. So the basic initial salami is 18,000, it's stipulated. Once there's allotment of the plot on the basis of the allotment, it might require more salami to be paid. Once the salami is paid according to the parameters indicated specifically, then it becomes ripe for possession to be given and Lord execution registration of sale deed. So possession will not precede the payment of the entire salami. That's J. Please read J at page 36 with A at page 35 and harmonize, Lord. Now, Lord K, any amount paid in excess of the premium or salami as may be found on final calculation by the government will be refunded after the execution and registration of the lease deed without any interest. After full payment of all the dues, you will have to get the lease drawn up, executed and registered within the time prescribed. All expenditure thereof will have to be borne by you. Now, a certified copy of the lease deed will have to be made over by you to the government within 60 days from the date of registration of the lease deed, and you will have to take delivery of possession of your plot as and when called for. Failure to take delivery of possession of the plot within the specific time may lead to cancellation of allotment and resumption of the plot in the appropriate manner, and in that event the amount of salami paid by you will be refunded after deducting therefrom rupees 50 as administrative charges. So the basic, my lord, construct, my lord, of the offer, my lord, has seen. Immediately, my lord, in terms of, my lord, may I show you, lordship, with the other portions also, lest, my lord, my learned friends say that I have not placed the entire document. 37, just for your lordship's kind consideration, NO, P, Q, N is a condition subsequent, that is after you get possession. You will be required to construct your house within 3 years from the date of taking possession. O, P, Q, and R in my reciprocal submission are not relevant for the purpose of the present cancellation. Now, my lord, kindly come to page 38. The salami or premium is paid to me. Is paid by me, I'm sorry, my wife. That's at page 38. Bithika Bonik, if your lordship kindly sees it in landscape mode. Salami or premium, as per government letter number so-and-so, rupees 18,000, capital outlay, stamped as received. Now, my lord, next page also is a continuation, my lord, of that receipt. According to me, my lord, by that payment, I have accepted the terms of the offer and a concluded executory contract has taken place. However, executory contract in this case has 2 limbs. One limb would be performances further by the government, pursuant to which, and as a condition subsequent to which, will be performances on my part. My lord has seen, my lord, the construct. Now, my lord, kindly comes till about 31st of July 2006, my lord. This was not given, my lord, to us. The allotment was not made to us. My lord, on 31st of July 2006, my lord, we write, my lord, to the authority. My wife writes to the authority. That's at page 40. This is to inform you that a 3 kathas plot of land in Bidhannagar was allotted in my favor under Metropolitan Development Department, Government of West Bengal, dated 19th April 1989. Full payment of salami was made within the stipulated time as per offer letter. Now kindly take it note that Ajanta Food Care India Private Limited is our family business, and I am one of the business directors of that concern. Due to some business trouble and family disturbances, I could not select any plot of land. Now I overcome the business and family trouble and in a position to start the construction work as soon as the pending formalities for selection of the plot and registration of lease deed is completed. I have already requested the concerned executive engineer in this regard. Under the above facts and circumstances, I request you to heartily realize my earlier difficulties allow me to select a 3-kata plot after condoning the unavoidable delay so that I can register the lease deed and take up the construction work immediately. This is in 2006. Now, my lord, in answer to this, my lord, we do not get any response. 22nd of June 2006, we had, my lord, written earlier regarding, my lord, our difficulties and condoning the delay, unavailable delay in selection of the plot. I'll address that, my lord, as a separate point. Now, my lord, kindly come, my lord, to page 42. After getting this, my lord, on the 31st of July, August 2007, the government therefore acknowledges that there is a continuing offer scenario which has been accepted, because they don't say that anything on our part is there which has caused the offer to die out. It's not their case. Please see, my lord, 31st of August 2007, letter at page 42 of my lord's brief.
Yes.
From land manager, OSD and ex officio deputy secretary to the government of West Bengal, to Srimati Bithika Bonik, care of Shri Subroto Bonik, Ajanta House, Kolkata 14. Subject, plot of land in Bidhannagar, Salt Lake City. Madam, I am directed to refer to your letter dated 11th of July 2007 on the above mentioned subject, and to request you to furnish the ownership of Ajanta House 79/2 AJC Bose Road, Kolkata 14. On receipt of the above reply, further process will follow. Therefore, clarify about Ajanta House and the process will follow. No other impediment, either between the lines or otherwise, has been mentioned here. Now, my lord, kindly sees, I clarify, page 43, my lord. Lord, kindly now come, Lord, to my letter, which I have given in response. 1st of October 2007, top left hand, my lord, is the date. To the land manager, OSD and ex officio deputy secretary, subject plot of land in Bidhannagar. Sir, in reply to your memo number such and such dated 31st of August 2007 / 7 September 2007, I am informing you that Ajanta House at 79/2 AJC Bose Road, Kolkata 14 is a registered office of our proprietorship firm in the name and style Messrs. Bonik Rubber Industries, of which myself and my husband Sri Subroto Bonik are proprietors. This is not a residential premises. I hope you are satisfied with my above reply. The query was made because whether I own any other residential premises or not was the query. I said no, there is an Ajanta House, which is a property which is held, my lord, by the company. And that particular premises is not a residential premises. It's used as the office of Ajanta House. Now I request you to note that I have deposited full amount of salami for a 3-kata plot of land at Bidhannagar, Salt Lake City, allotted in my name under Metropolitan Development Department, Government of West Bengal, order number such and such dated 19th April 1989. But after a lapse of so many years, government had not earmarked any particular plot of land in my favor till yet. As such, lease deed has not been executed and registered. Above salami amount so and so was lying with the government accounts in last 18 years. I am to request you to kindly earmark 1 3-kata plot at Salt Lake City immediately, and to complete the follow-up action towards delivery of possession of the said plot as early as possible. This, my lord, is received, my lord, as on the 1st of October 2007. The state does not immediately come back with any kind of denial of the claim. State does not say anything adverse until page 45. And page 45 is the one, my lord, which I have shown your lordship. Now, my lord, kindly see, this order contains the following reasons for the alleged cancellation of offer. Number 1, that Bithika Bonik has not approached to this department to choose a plot of land at Salt Lake City within the scheduled offer dates. 2 dates are mentioned, 4th of September 1989 and on 25th of April 1991. Please be satisfied when I submit from the letter of offer that there was no stipulation in the letter of offer regarding my having to go and approach them within a stipulated period, in default of which my offer would stand cancelled. My lord, I have scanned through the particular provisions, my lord, of the offer letter. That's at page P1, page 35. Please be satisfied when I submit, after going through, my lord, the respective paragraphs of that offer letter, that there is no condition given there that there is a particular date within which you are required to make a selection. If you don't make a selection, that amounts to the offer dying out.
Where is this letter, Mr. Banerjee? 25th of April 1991, which finds mention in the letter dated March 18, 2009. The first paragraph.
Yes, so this is my instructions are, I've sought 4th of September 1989.
This page 35 which you showed.
Page 35, yes.
That is page 35.
Yes.
1989 is page 35.
Yes.
What is this 25/4/1991? No, page 35 is also 19/4/1989.
19/4/1989.
Where are these letters? September 4, 1989 and April 25, 1991.
No, 4th September 1989 and on 25th of April 1991, my lord, I am told, my lord, that no letters were given. There's no letter on record. There's no letter on record by which we were sought to exercise our option. Now, my lord, this has come in, according to me, for the first time in this particular letter of cancellation. There is no letter of record, my lord, showing that we were given any choice, a date to exercise our option. So, my lord, on the option, I have threefold submissions. Number one, in the offer letter, acceptance was to be made by payment of the amount of average salami, 6,000 into 3, that is 18,000. I accepted the offer letter, it became an executory contract. In the terms of the offer letter, there was no mention whatsoever about any stipulated point of time within which I should exercise my offer, or rather my choice. There was no mention also of the fact that if I do not exercise my choice within that period, the offer would stand cancelled.
No default clause.
My lord?
There was no default clause.
There is no default clause. Therefore, there is no default clause on the non-selection of plot by me at any stipulated period of time.
There was a default clause in respect to other conditions.
The default clause that is there, my lord, is F. F at page 36.
In respect of payment not being made in time.
Final payment. That is, I have given 18,000 at the average price. Now, depending on the situs of the plot to be ultimately given to me, I may be required to make payment of additional amount, 10%, 15%, depending on situs. That amount I will have to pay after final measurement is done. No possession will be handed over to me. So the steps are like this. Number one, their offer letter. Number two, my acceptance, executory contract. Number three, they're offering to me a plot which I accept, or if I don't accept, they're offering to me a plot which I must accept. Once they offer that to me, then there is a question of measurement of that plot in order to see, and the situs is to be gone into in order to see whether any of the additional payments as contemplated by A are required to be made. Once that is done, the additional payments, if any, are calculated, made over to me, and then I make the calculation is made over to me. I make the balance payments. As soon as I make the balance payments, I make the entire transaction. The next gate opens, and now the question would come for execution, registration of lease deed, accompanied by delivery of possession. That's only after I pay the salami. Now, in payment of salami, also, my lord has seen, there is at least a window of 3 years. There are two rates of interest that are mentioned. One is 7% for the first 2 years and 10% for the third year, B1 at page 35. Please have a look at B1 again. Payment of full amount of the said salami or premium calculated provisionally at the said rate in one installment, which I have done, as may be finally calculated on the basis, within 90 days from the date of this letter, and the balance salami as may be finally calculated on the basis of actual measurement of the plot and the location of the plot after selection of the plot of the same within 90 days from the date of demand, failing which interest at the rate of 7% per annum will be charged for the first 2 years and 10% for the third year. So I may pay it at one go. I may not pay it at one go. Even after the measurements are complete and I am told to make payment of the balance, I may pay it immediately. If I don't pay it immediately, for the first year, there will be 7% interest charge, first 2 years. And from the third year, 10%.
If you have not paid, then there is a forfeiture. I mean, there is a cancellation.
So entire working out complete, they give me a final demand. I don't pay, I sit over it for 3 years without paying. Because up to 3 years, I'm construing it as such, at least 3 years time is made available to me because of the fact that interest components have been mentioned for non-payment within that period. That means if I pay with interest, I'm through. After this entire thing has happened and I have paid, the second door is unlocked, then comes the question of giving execution registration of deed and handing over possession. If I have not paid within the period of 3 years with interest, my lord, then might come the question of cancellation. Here in the instant case, I have, my lord, accepted the offer.
If it was not on you to select any plot of land, then why did you write this 2006 letter saying
It
that
is written. I wanted to apologize because a long period of time had passed. I have not mentioned in my letter.
Say that I could not select a plot of land if it was not your owners at all.
I took it upon,
and it was on them only.
I took it upon. I took it upon myself to explain why I did not go ahead, why I did not go and contact and select the plot of land. I took it upon myself as a show of courtesy to the state. Please be satisfied when I submit that insofar as the offer is concerned, there was no stipulation for me to come forward. It could have been the other way around. That part has not been worked out in the offer. So, number one, if the state shows that I am given an offer and I say that I don't like this plot, therefore I am not satisfied with the choice given, that then the contract automatically goes. It's repudiated. In the event I say that I have not gone forward, then the state has to come forward with a particular choice selection given to me. And if your lordship has seen the final letter of cancellation, it mentions 2 dates. I am aware, my lord. My lord is looking for a documentary evidence of those 2 letters. I have searched, my lord, in vain, and I have also taken instructions. There is no documentary evidence of any letter having been given to me. Even in my letter, my lord, of 2007, when I first respond to them and say that I could not do it because of the fact that there were problems, my lord, with the company, there also I don't say that I was invited by you to come and select by letter of so and so, which I did not. Yes, there is a line which says I could not do it earlier because to showing courtesy to the state, I am saying that you have given me an offer which has crystallized in an allotment. I haven't gone forward to you and I haven't on my own asked for a particular selection, but they were under an obligation to give me that that field of choice which I ought to have selected. Because your lordship sees the entire grain, the contract, even reading between the lines, does not make a condition of my selection within a particular point of time a condition of breach. And a concluded contract has taken place. This is executory in all forms.
But is their stand on affidavit?
They haven't taken an affidavit. They have come up before your lordship's predecessor, my Lord Justice Shamanto, where the matter was heard and judgment reserved almost. They say they don't want to file an affidavit. They want to argue on whatever is there. Yes. Justice Shamanto, Lord. Lord, kindly see 7th of July 2025 order, 7/7/2025. After that, Lord, the matter was heard in extenso. My challenge here, my lord, is to the arbitrariness of the state in the manner in which they are now going back on a concluded action, deeming it to be an offer and cancelling it for alleged non-compliance of a non-existent default clause. The default clause on which they are falling back does not contemplate this present situation as a default at all.
How much more time will you need, Mr.?
Hardly 15 minutes.
You will be arguing for the state?
My lord, Mr. Loknath Chatterjee will be arguing.
Where is he?
My lord, he's standing on his feet in another court. He will be coming very soon.
No, today I have a fixed matter. I'll have to fix a date.
Then we can come back on any other date, my lord says, so that Mr. Chatterjee, his juniors have heard the arguments. I'll share also, my lord, the judgments that I would like to cite beforehand.
On 11th is next Friday. Next Friday will be a holiday. Friday week we can have it.
Friday week, my lords, kindly, my lord, Friday.
Mr. Mukherjee,
Grateful to Lord.
Heard Mr. Mukherjee, learned senior advocate, assisted by Mr. Banerjee, learned senior advocate representing the petitioners. Full stop. He is yet to conclude. Full stop. List this matter for further consideration on September 11, 2026 at 2 p.m. 2 p.m. would do, Mr. Mukherjee?
Yes, my lord, 2 p.m. would be of great
2
convenience.
p.m.
2 p.m.
2 p.m.
Oblige, your lordship. So that it can. Yes. My lord, would kindly, my lord, if your lordship kindly records, my lordship has heard it in part.
It's an assigned matter.
Oh, it's assigned to it. It will follow your lordship.
Grateful.
Grateful.
Back in time.
Interim order will expire this month. My learned friend is on the other side.
We can fix it and finish it. No? It's that
Yes.
matter that.
There are other fixed matter, my lord.
When can we have it?
As your lordship, my lord.
I'm always before.
একটা রেখে দিন না না কল করবো না হ্যাঁ ওটা কল করে দিন একবার interim order is still 31st.
31st.
I'll do this. 31st it will appear as for extension. রেখে দিন I'll fix a date on that day. I'll extend it for a limited period. Fix
Under the heading extension, it will happen.
Yes. ওটা এক্সটেনশনে দিয়ে দেবেন সোমবারে উপরে
Get
পরের গুলো ফিক্সড আছে তো there is a fixed matter at 12.
Blood. Sorry. Blood. I'm very happy, my lord, to appear in this matter for a simple reason, my lord, that everything is quite well and done and over with, my lord. I have only to give, my lord, finishing touches, and I'm extremely happy to, my lord, to do this. It's the best thing that could have happened to me. I don't know about your lordship, my lord. To me, my lord, this has been a boon. I'll take 10 minutes of my lord's time, nothing more than that. So, কিছু অসুবিধা আছে?
Mr. Bhattacharya had almost concluded.
Yeah, he has concluded, he has shown your lordship judgments, he's done everything, but even then he wants me to appear. I'm so grateful to him. না একদম কোনো এতে নেই there's just two things. Well, facts are admitted. I don't even need to tell your lordship on that. Law is also admitted. I'll just give your lordship two judgments and conclude and let my learned friend conclude. Very Milord, your lordship takes up. I'm বলছি দাঁড়া এক সেকেন্ড দাঁড়া গড়বড় করিস না এক সেকেন্ড দাঁড়া সুনিতা দেবী তে বলছি সুনিতা দেবী ভার্সেস হাজি আব্দুল রাজাক এটা একটা সুপ্রিম টুডে থেকে নিয়েছে নাম লিখে নিতে এই যে এখানে সবকটা দেয়া আছে Lord, your lordship knows about that Seventh-day Adventist which is there. Lord, the basic thing that I wanted to show your lordship, but lordship knows it because there's my lord's judgment as well. Lord, if you don't come within that 7-1 period, then Lord, there's no question of Lord, any section 5 happening or any delay or anything of that sort. If you've come within that period, Lord, it's become very rigid. Lord, I personally, Lord, I tried a lot before my lord, before Justice Bhattacharya, Lord, but all those judgments, Lord,
has become difficult because
very difficult now, and it's absolutely yes. Even reverse corporation, where probably I tried my level best there, my lord, even before Justice Bhattacharya, but after Debashish Pal came into the picture, my lord, the hands of the courts are tied. Now, this judgment, Sunita Devi, my lord, your lordship will see. আমি এখানে মার্ক করেছি
my lord will see paragraph 10. These are all that your lordship knows. And just to remind your lordship, my lord, it is well settled that the provision, my lord kindly got it. 7.1 and 7.2 are mandatory. The time limit prescribed for deposit of area rent and current rent is incorporated within the sections themselves. Section 5 of the Limitation Act is not applicable. And this is, Lord, this has been the consistent view. That Section 5, Lord, why Section 5 not applicable is, respectfully submitting, is that 7.1 doesn't even contemplate of an application. If there is no application, Lord, there is no question of 7.1 at all. Now, the problem that the tenants face, and that's what the law is, earlier, Lord, it was a beneficial legislation, Lord, for the tenants. Now, after Nasiruddin, Lord, it says that it's a beneficial legislation for both landlords and tenants. So, if he has to have, Lord, the benefits of 7.4 or whatever,
Has to have it within
has
the
to have it within the framework of the Act. Lord, your Lordship sees the Act once, and there is a very important part there. Lordship, premises and C7.1 once.
Yes.
On a suit being instituted by the landlord for eviction on any of the grounds referred to in section 6, the tenant shall, subject to the provisions of subsection 2 of this act, pay to the landlord. This is important. He has an option, my lord, to pay to the landlord because it's my.
That on the
Yes,
last
he's
occasion,
argued. Very good. Pay to the landlord or deposit with civil judge all areas of rent calculated at the rate at which it was last paid.
Only problem there, Mr. Chatterjee, was that even if there is an option that he will either pay to the landlord or deposit in court. Once he chooses one of the two options that he would deposit in court, there may be no reason for him to go back to the first option.
No.
Now he has chosen one of the options.
Yes, sir.
That I will deposit in court. He has gone to the court. Now, as has been shown by Mr. Banerjee, that there is a judgment of this court recognizing a practice going on. Yes. Going on in city civil court that rent deposits are not accepted till such time that it is accompanied by an order passed by the court saying you accept.
Now the problem is smart was way back. Thereafter,
has the practice changed?
No, the practice might whatever might be.
Now, problem there, Mr. Banerjee,
If the
is
practice has
what he invokes is the act of court logic. He says that I filed the application in time. The minimum time which was available to me, I made the best utilization of that. Came to the court in time. Whatever was doable at my end, I have done it. Now, after
But
having
hasn't
done
deposited the money.
How will I?
That is where I am.
Yes.
Because then Mr. Banerjee has to show the court that he came with the money, wanted to deposit it, but could not deposit.
But how can that be documented?
But that's a process of court. That challan
documented
where,
because if
there
he
is
goes
a
with a
challan.
challan, the receiving clerk will orally say, I will not take. Where is the
Has
order?
he even said that before your lordship? Has he even said that? I understand, my lord, his practical difficulties. He goes every day. But has he even told your lordship's court that I was there? I tried to put in, but I could not. That's a factual thing. And that needs to be adjudicated by the court below. He hasn't even made that below submission before.
There is no application subsequent to the 7.1 saying that it was
nothing. And if they say, my lord, that 7.1 that I am in difficulty, put it up before the court. See, tell the court that I have
in
this.
one of the cases I had an occasion to deal with this situation.
Has to. Manav Chaudhary will show that. We'll show that. We have that before your lordship. Now, there is a way of playing around with provisions. It can. And I tell your lordship, there is in the code itself, in the act itself. You don't need. On that matter. Like, But what is my bona fide? The tenants have to come within that act because it's beneficial for you. So if you want to have a benefit out of the act, then you have to go within the rigors of the act. You can't say that, look here, that was one of judgment passed by Justice Banerjee. The other judgments are completely different. Practicality, very well, practicality I understand. But that the court, which is where the difficulty is happening, that court would adjudicate that, not the higher court. My lord, if we had any difficulty before your lordship, we'll come and tell your lordship, not the Supreme Court. It is that court to, my lord, find out. My lord, there was one instance where Justice Basu wanted to, my lord, lay down this law. His lordship wanted to, my lord, say that after the first date, the second date should come within 1 month. His lordship wanted to, my lord, lay down that. Practically, that would have been the best. But where is that law? My lord, may I ask this question to myself? Nowhere. So what is to be done? A tenant who really is bona fide will go and put it up to the court and look here, if you don't give me time to deposit by now, I am in difficulty. But if you sit tight over the matter and say, Amar, I have done whatever I have done, that's not what the law is. So it's not just beneficial for him, Nasiruddin's judgment, my lord. Not just beneficial for him, it's beneficial for me. Because a valuable right accrues. Moment he doesn't put in the money, my lord, within 7-1, a valuable right accrues on me when I can get his defense struck off. Now, this is one judgment, my lord, your lordship has seen. I am not troubling your lordship. Paragraph 10, your lordship would see. And Seventh-day Adventist, my lord, is quoted here. It's also quoted there, my lord, in paragraph 13. It's quoted, so I need not trouble your lordship, my lord, to go into the other judgment again. It's quoted at paragraph 13. Then my lord's judgment, my lord, which your lordship, my lord, has given in Sumit Singh. This is your lordship's judgment. It's there, my lord, before your lordship, with your lordship. Again, I'm not going to, my lord, trouble my lord's self with the entire, just that, but it's the same thing. I'm not, my lord. দাদা এই প্রবলেম হলো এই সাইটেশন গুলো রিপোর্ট আনরিভ একটা কপি দে তাহলে তোমার কপি দিয়েছে বলছি সুমিনে দিয়েছে হ্যাঁ এটা দাদাকে দে না হ্যাঁ look at paragraph 32 বলছে রেফারেন্স আসবে কোনটা তো সুস্মিতা স্যার এখন মনে হয় সুমিত ওটাই বলছে হ্যাঁ সুমিতা দেবী হ্যাঁ হ্যাঁ না না সুমিতা দেবী না সুমিত সিং জাস্ট গিভ মি সাইটকে দেওয়া হয় সুমিতা দেবী জজ সাহেবকে দেবো জজ সাহেবকে দিসনি My lord, your lordship has Sumit Singh, my lord's judgment.
Yes, it was placed. Last time it was placed.
32. Same thing. Need not waste your lordship's time, just for the sake of, my lord, citing it. Similarly, my lord, Atish Dash is a little bit more elaborately said by Justice Shortcut. It's been there. (2023) 4CHN 653. 23 4CHN 653. My lord, here a lot of other judgments were taken into consideration. Cease paragraph 5. I am not reading because it's almost the same. Then, my lord, your lordship sees paragraph 11, where the section has been quoted. Or rather, 10, the section has been quoted. 11, my lord, here that part of paying to the landlord has been, my lord, taken care of. And then, as per section 7(1)(b) of the said act, the admitted area rent must be deposited. by the defendants within 1 month from the date of service of summons on him or where he appears in the suit without summons. My lord, in our case, it's an admitted thing, my lord, he hasn't done. Now, deposit, suppose, my lord, I have a problem depositing it in court. He has an option to come and deposit with me. You say practical difficulty, but Smart never looked into that that aspect where there was an option for them to use, my lord, to pay to the landlord. Smart never, my lord, even looked into that part of the provision which said that if they were that bona fide, they would have come and paid to the landlord. So Smart, in my respectful submission, doesn't hold good anymore, my lord, after the judgments of Seventh-day Adventists and Devashish Pal, and there was one more just before Devashish Pal. So it becomes very strict, and my lord, today we are appearing for landlords, but mostly we appear for tenants. We know what the problem is. But this is a problem, the legislature wants it this way. The courts, my lord, in my respectful submission, can't, my lord, get it more lenient than what it is. আর কিছু দেখাবি? কোনটা? এটা হচ্ছে অতীশ দাস, ফাতেয়া বেগম মোল্লা. Deepcha Thirawat, my lord, is, yes, it's a little important. Look to 2930. No, I am not even on that. I am taking it a little further. I am saying, my lord, once you have filed 7-1, you may not have filed 7-1, but once you have filed 7-1 means you know that there is an arrear in rent. Once you know that there is an arrear of rent, you will have to put in the money. Because the submission is made because of the landlord-tenant relationship, my lord, is to be. But here 29 and 30, my lord, says that even if you do that, you will have to put in the admitted rent. 29 and 30. My lord, I am going a little further than that. Moment you come under 7-1, you are admitting that there is an arrear of rent. Once there is an admitted arrear of rent, you will have to put in the money in terms of 7-1.
Yes.
My lord's judgment again. Mr. Bhattacharya loves his judgment, my lord. Receiving it. It boils down to the same thing. Your lordship need not trouble my lordship. হ্যাঁ, ঠিক আছে। The facts, my lord, are somewhat similar. The applications were made later. Your lordship has said nothing doing. Once the act is that, you can't go beyond that. Mr. Bhattacharya would be very annoyed, my lord, if he if he loses both ways. I need not, my lord. Clubbing of rent. This is one point I should address. Now, my lord, once your lordship, this clubbing of rent, under 7-1A, clubbing of rent is absolutely permitted. But 7-1C, you can. 7-1C, my lord, you are paying the current rent. You have to put in within that period of that month. So you can't say that I put in 3 months together and that is clubbing of rent. Can't happen. That is 65 Supreme Court as well. But the law, again, my lord, is quite clear. Mr. Bhattacharya has given your lordship that 7-1A, there is no problem. But 7-1C, my lord, it needs to be paid then and there. Those are 100 and 106. তো বলেছিস তো যত আবার কেন বলা? That's it, my lord.
Yes, Mr. Banerjee.
My lord, we had given to your lordship the information that in between the pendency of 7-1 and 7-2, there was another application filed by the plaintiffs. Order 1, Rule 10-2. By that application, they asked for taking off the plaintiff numbers 3, 4, and 5 from the records and transpose them as pro forma defendants. Malad, these array of parties, this was changed during the pendency of this 7.1 and 7.2. Malad, therefore, the provision of service from the date of, from the date of service of summons in respect of 7.2 cannot apply. My lord will kindly see in another matter, the similar matter. Malad, there is a এটা হচ্ছে বিনোদ শর্মা সেম পার্টি সেম বিল্ডিং হ্যাঁ same landlord, but it would start not from the date of service of summons but from the date of transposition. But this matter is still pending before Justice Bhattacharya. No, it's not binding. But similar circumstance in this matter. But the dates of the orders are also absolutely identical. But this is my first point. My second point before your lordship.
When have you transposed?
মানে the transposition date টা কবে বল? এটা আমার ব্রিফটা। Malad, it was allowed on 2nd August 2024, para 11 of the revisional application we have stated. Malad, Annexure E is the order.
Para 11.
Yes.
September, not August. It's 69.
No, 68 that. 69 বলছে, date 69 বলছে।
Para 11 is deletion.
Lordship?
Deletion of somebody's name, not transposition.
Not deletion, it is transposition that had happened.
Para 11 is deletion. Deletion of the name of defendant number 1.
But I'm sorry, my lord, kindly comes to page 69.
Page 69.
26/9/2024.
26/9/2024. Yes.
But this is the date on which it was allowed.
Yes, but you were not transposed. You remained the defendant.
But I remained the defendant. But the status of the landlords that as was given in the plaint, that has changed. But we raised the dispute. In the 7.1 and 7.2, we raised the dispute that plaintiff numbers 1 to 3 are my landlords, but 4 to 6 are not my landlords. Malad, during pendency of that application, they admitted that. On that admission, Order 1, Rule 10 was filed by them.
But the person whom you admitted to be your landlord remained your landlord from day one.
Remained my landlord.
Anyways, I'll take.
Malad, this is a circumstance, my lord, that the array of parties as given in the suit that had changed during the pendency of the matter. Malad, the judgments
Yes.
But we had cited the judgment of Justice Horish Tandon. Lordship has that. But that judgment says that it is not required to be moved again and again. And Malad, that judgment by Justice Hiranmoy Bhattacharya that has been distinguished in the subsequent judgment given in Ashaben Mehta. But that we have cited already before your lordship. Malad, the dates are absolutely identical, points, facts, everything identical. Malad, 30 matters filed. Out of that, we are before your lordship with one matter, one before Justice Bhattacharya. Now, Malad, the most important thing is the judgments that they have cited today before your lordship, Malad, kindly takes up. The first one that is by your lordship, Malad, Sumit Singh.
My judgments are usually wrong judgments. I will not.
But I never say it is wrong, but factually.
I will not go by that. You can be rest assured. I will not.
But I would have
follow
been.
it.
But I would have been so very happy if it would have been wrong, Milord. But paragraph 3 and 4, kindly see the facts are absolutely different. Milord, here 7-1 was allowed, not deposited within time. 151 was invoked to deposit. In my case, it is absolutely different. This is the first one. The second one that they have cited, that is Justice Shampa Sarkar. The name is Sunita Devi Shao and others.
Yes.
Sunita Devi Shao. Lordship will kindly come to paragraph number 5.
Yes, Sunita Devi Shah.
Malad, this was challenging an order allowing 7-3. Malad, here the defendant got an opportunity to deposit. Lordship will kindly come to para 5.
Yes.
Malad, the defendant consciously did not comply with the provisions of 7-1 and was asking for the same relief for the second time in the suit. Malad, in our case, 7-1 was allowed, we deposited. While disposal of the 7-2, the court came up with an observation that your deposit are out of time. This is the change in the circumstances in respect of these two matters. Ar konta bol ora dekhiyeche. মানে the other judgment Manav Chaudhuri, এটা আমি ছিলাম না।
একদিকে মানব সাহারা একদিকে সিটি কোর্টের রাজা দুজন
সিটি কোর্ট না, হাইকোর্টেরটা তো ছিল কৌশিকের মামলা, তো সেই কৌশিক
সেই
মানব চৌধুরী
এখনো আছে।
Yes.
Malad, kindly see. Malad, if Lordship will kindly consider para 14 onwards. Malad, order was passed by the learned Chief Judge. They did not deposit in time. Then they applied, kindly permit me to deposit. Malad, absolutely different set of circumstance. But perhaps I had appeared in the matter, but my name is not there.
Maybe on the final day when it was argued.
Maybe. Joseph, আমার নাম লিখতে চান না?
Yes.
আর কি দিয়েছে ওরা? একটু সিএইচএন এর কপিটা দেন, তোরা যেটা দিয়েছিস সিএইচএন একটা দিয়েছিস, ওটা খুঁজে পেলাম না এই মুহূর্তে। অফিসের মাঝখানে আরো সব আছে না? Malad, kindly see, Justice, this is Atish Das.
Atish Das. Yes.
মানে কি পাবো তোরা? But kindly see, 7-2 was filed. 7.1 was not complied. Admitted arrears of rent were not paid. But the situation that Mr. Chatterjee has just now demonstrated before your lordship, why didn't I say that I tried to pay but I could not? But in small causes court, city civil court without orders, unlike the other civil courts, Milord, challans are not passed. কোনো রকম চালান পাস হয় না মানে lordship can call for a report also from this court, but there is a matter in which I have got that report from the department, but I have got that because I have to place it before your lordship or whatever benches at that time when it is available. Malad, in fact, Malad, I have the information from the computer section that it was uploaded at a time after the date of deposit was over. But these are happening. We cannot help.
Yes.
My lord will, my lord, once, my lord, just for my sake, my lord, kindly consider Justice Hiranmoy Bhattacharya judgment, Shochindra Kumar Jha versus Asha Bansal. We have cited, my lord. এই আছে, নে না। জজ সাহেব কি যা যা দিয়েছিস কম্পাইল করে দেয়।
আপনি সব একসঙ্গে রেখে দিয়েছেন তো, কিছু খুঁজে পাওয়া যায় না, আলাদা আলাদা না করলে আমার অসুবিধা হবে। বারবার বলি আপনি সব একসঙ্গে রেখে দেন, ওরা কতবার দেবে একই জিনিস? I have smart cited by you. Then Shochindra Kumar Jha I have got. Eta ফেরত দিন। Then Dilip Das. And then Mary Pushpam.
Supreme Court.
Mary Pushpam.
Yes.
These four.
And Justice Horish Tandon judgment?
Yes, that I have.
Yes.
That is what I said. Dilip Das is Justice Tandon's judgment.
Yes.
Dilip Das. So four you have.
আর কিছু দিয়েছিলি?
That is Mary Pushpam.
নামটা দেখ।
2024, 3rd January 2024. Yes,
yes.
So these are the four judges.
Yes.
Mary Pushpam 1, Dilip Das by Justice Tandon, Shochindra Kumar Jha by Justice Bhattacharya, and Smart Enterprises by Justice Banerjee.
My lord, lordship will kindly consider paragraph number 11 onwards
Of
but
Shochindra
of
Kumar
the
Jha.
Justice Hiranmoy Bhattacharya judgment.
Paragraph 11. Yes.
My lord, the dates and events are identical to this matter. My lord will kindly consider this, how the other judgment, that is West Bengal Handloom Weavers Cooperative Society Limited, but in parlance with the submission of Mr. Chatterjee, why didn't I approach the court on each and every occasion asking the court to give me the permission to deposit? Why I did not make it? My lord, this has been differentiated in paragraph number 30. My lord, that is also a judgment passed by Justice Hiranmoy Bhattacharya. But Justice Bhattacharya differed from that in considering this particular matter, which is identical to this matter.
Yes.
Archaeologists.
And what about clubbing?
Clubbing.
Clubbing of friends? Three months you have deposited with, then there is a default of the first 2 months. If it has to be by the 15th of the next succeeding month, and you have deposited 3 months together,
But if the deposit is in advance,
it is not in advance.
but it is in advance, I can show
One
that.
case it is, in one case it is not. One is sufficient. Even if I go by that logic,
এটা তো
the last occasion it
consider
was
করে।
pointed out.
But this is not a consideration by the trial court.
It's 7-1, materials are there.
My lord, I am encountering something absolutely unknown. But if meticulously challans are to be seen, it would be seen that deposits are made. Some
He has made this submission, and that is apparent from the records. Your
100 and 106.
your records have been shown. How will I ignore that?
My lord,
Mr. Bhattacharya specifically pointed this out on the last occasion.
5/2023
Please see 106.
106
Yes.
এটা তো কোর্টের অর্ডারে জমা দিয়েছিস। But this is by a court's order.
So what? You are depositing how
My
much?
lord, my application was pending. My lord, my application was within time.
7C has to go month by month by 15th of the succeeding
Yes.
month.
Yes.
Now you are paying on 20th of March 2023 months for November, December, January, February, March. So even if I take February to be within time, February is also not within time. It's beyond 15th.
Lordship will kindly
January,
consider.
February, March, all.
Lordship will kindly consider the judgment of Justice Bhattacharya, paragraph number 12. Paragraph number 12. But when the order was passed and when the deposit was made. My lord, this period, my lord, this was a period when my application was pending before the court, and that application was within time. My lord, the deposits that were made. My lord, kindly see, 11/7/2024 is the date of order. And we have deposited on 2nd August 2024. এইটা জজ সাহেব জানতে চাইছেন, এইটা সিটি সিভিল কোড ডিপোজিটটা, এইটা কেন দেরি হলো? মানে this was deposited after the order was passed. আটের তো না, এটা মার্চেরটা কি করে হলো সেটা বল। হ্যাঁ, তো এই টাকাটা কি করে, মানে এইটার সঙ্গে ম্যাচ করছে না। জজ সাহেব যেটা প্রশ্ন করছেন, জজ সাহেব যেটা জিজ্ঞেস করছেন এইটার ব্যাপারে না, এই ডিপোজিটটা যেটা 106-তে দেখিয়েছিস, এইটা কেন দেরি হলো? অর্ডারটা ডেটটা জজ সাহেবকে বল। February. The order was passed on 28th February 23. It's 28/2/2023. And thereafter,
so according to you, these were all arrears.
But arrears coming under the order. But that is what is expressed in paragraph number 12, 7 and 12 of the judgment of Justice Bhattacharya. But I was under the shelter of the court by filing my application. The only thing, as Mr. Chatterjee reiterates, I did not go to the court and every day make a prayer why you are not accepting it.
Very well.
pay to the landlord, my lord, there is no answer.
The provision is all, my lord. And I cannot make a prayer by putting court fees before the landlord.
Arey, you are paying to the landlord. Yeah, Mr. Banerjee, you know better than that.
But only one paragraph of the revisional application, page 29, para 4. Application under 7.1 and 7.2. But we reiterate in 7.2 that we had tendered the rent. The landlord had refused it. Yes. But pre-suit, he did not take. But post-suit, it is not expected that he will take. And at that time, I had invoked my rights before the court of law.
Very well, I shall consider. Heard, Mr.
September.
18 September.
18 September.
The next matter kindly takes it up next week. Item number 30.
There is another one at 12:30. সেটা call করুন।
12 noon, my lord, next. Oh, the next Friday is a holiday.
Next to next.
11. Thursday at 12.
Next Friday.
Next
Friday week. Yes, sure. 12:30 call.
Great.
Basu is coming, my lord. The Basu is coming. Just starting. Now, if the purchaser, my lord, আরে যে যে composite reply দিতে পারবো তো। You have anything to say? They have started. If they complete, then I can give a composite. You can give a composite reply. Why you are objecting?
No, I am not.
See, it's upon the purchaser.
Wait. You take this. Very well. If any new point is taken, I'll give you opportunity to reply. Because you also have a writ petitioner, so you will also have right to close your writ petition.
Well,
The writ petitioner should always close his. He also is a writ petitioner at one place.
Yes.
So he will also have a right to close arguments in his writ petition. Not a problem. Yes.
well, in my understanding, বাজে কথা বলবো না কেন বলবো? In my understanding, my lord, the entire point, my lord, argued before your lordship by the borrower. I don't know, I come to this point later whether they have at all. না কি বলবেন বলেছিলাম ওনারা বলবেন
না পরে আবার কি
না যশের কাছে নতুন পয়েন্ট থাকলে বলবেন নাহলে আমরাই শেষ করে দেবো আজকে
আমার বিপ দেন না আমি তো ব্রিট মিনিস্টার ট্রেসই করি না my lord has ample experience in SARFAESI Act, much more experience than me. I can say that. What is SARFAESI Act? Borrower taking loan, you have to repay. If you don't repay, consequence will follow. Only thing what is to be looked into, that while selling the property, the non-mortgage property should not be sold. Apart from that, there is nothing. This is my understanding. These are technicalities. English speaking benefited us, nothing, no one else. Now, my lord, here is a case. My lord has civil division jurisdiction. My lord has taken. My lord has taken, as a lawyer, my lord appeared in so many matters where your lordship prayed for disposal of the suit, early disposal of the suit. In that petition, may I ask this question to myself? First line of the order is, if it is not served, that the nature of the order is court is going to pass, the opposite party need not be served. This is the first line of this order. Suppose there is a service. Would your lordship, my lord, allow the opposite party to say that no. Kindly don't pass any order for expedient disposal of the suit. The suit is not maintainable. In my experience, in my humble understanding, the opposite party cannot set this in a proceeding where a petitioner is come either plaintiff or defendant for expeditious disposal of his suit. Kindly apply the test here. What is my writ petition? My writ petition is once section 14 application has been filed before the magistrate court jurisdictional authority, kindly direct to disposal of that. Where in this proceeding, even if the parties are arrayed there, can they demonstrate before my lord? No. Section 14 application is not maintainable. Can your lordship's court in this proceeding will decide that? So for my understanding of the law is, this point cannot be at all agitated in a normal course. Here is a proceeding under SARFAESI Act. Section 14 is a proceeding, is not under the judicial proceeding, it is a administrative proceeding in so many words. And the interpreting section 14, Supreme Court has said that you need not serve a notice upon the borrower or borrower. This is the, my lord, finding up till date. If that is holding the field today of the law, that a section 14 notice need not be served, and a prayer has been made by the writ petitioner for early disposal of section 14 application, whether the parties in this proceeding, accepting the petitioner, can urge even that no, this section 14 application is not maintainable. You cannot touch it. This is my first limb of submission. Secondly, my lord, I am replying and making my submission so far as my writ petition is concerned for early disposal of section 17. But what section 14 authority can do, it is fully aware. Only 9 points he has to consider. It is in your lordship memory, I need not trouble your lordship. Yes. Section 14 authority what can do? These 9 points. Well, I am accepting. Is this fellow is asking for the books? In SARFAESI Act? No. No, yes. Certainly not. Certainly not. Yes. These 9 points. For the time being, I am accepting that Mr. Banerjee Melot can argue. My first submission is cannot argue. Even if he can argue, what he can argue, that 9 points of this, which the authority will consider, there is misleading statement on the face of it. Although the 14 court authority can decide that, he has to be satisfied. Language is, he has to verify and satisfy it. I can go to that extent. No, Mr. Banerjee can certainly people. This 9 points is 1, 2, 3, 4. On the face of it, it appears this is misleading statement, suppression of fact, everything is there. His contention is, well, let us go through 1 to 9. What he has said in my humble submission, what he has said, suppression. What is the suppression? Suppression is the property is tenanted, not been said. This is suppression. But kindly be sure from these 9 points where it is required to disclose whether property is encumbered or not. This may be in the sale notice. And if the sale notice there is suppression, who can challenge that? Because if it is encumbered, property will be fetched less value. He is saying encumbered. Can you see? Not otherwise. He is not saying that property is not encumbered. It has been said as encumbered. So the value of the property may be reduced. Mr. Bhattacharya can say. But whether a borrower can say, I'm asking the question to myself. Particularly when there is in the 9 point, there is no provision that you have to disclose whether the property is encumbered or not. Now, another thing, if I'm wrong, my lord, kindly correct me. He has said the 13 to notice 6, affirming that the period of 60 days notice as required by the provision of subsection 2 of section 13, demanding payment of the defaulted financial assistance has been served on the borrower. This point was also subject matter of challenge before section 17. I will show to your lordship, the 17 court had categorically decided that keeping an issue and decided that point the 13-2 order is valid, which is subject matter of appeal, but no stay. I can go to that extent. When the order is under appeal, it loses its finality. But unless it is stayed, it has a force. Can he, when he has taken the substantive point in the appeal, before your lordship's court, in 226, in a writ petition filed by the bank for expeditious disposal of section 14 application, can agitate this point? But kindly once come to the appeal. Page 21.
Page 21.
Page 21 is the order under 17.
Final judgment.
This is a final judgment which is appealed against.
Page 21 is NEFT receipt, something in your writ petition.
My writ petition I am arguing.
15541.
You know. একবার খালি got it. দিদি একটু দেখে দিন তো অন্য ফাইল বোধহয় চলে গেছে।
Page 21.
Yes, it starts. Kindly come to page 27. What a borrower can urge at best in a surface matter, that NPA is not correct. If NPA goes, everything goes. But kindly come to paragraph 30. I will not trouble your lordship to state the entirety. After all, my lord, it comes to page 29. It decided finally, hence there has been no irregularity in classifying the loan account of the applicant as NPA. It has not been stayed. And appeal has been preferred. If your lordship is asked to decide this question, that my lord will be prejudging the issue in that. Then my lord, kindly come to 13(3)(a), not necessary, kindly come to paragraph 42. Paragraph 45, page 30. Therefore, the 13(2) notice issued in the instant case is not a mere formality. Rather, all the details regarding details of the amount payable by the borrower and the description of the secured assets intending to be enforced by the secured creditors in the event of non-payment has been mentioned in the notice. In the above cited judgments of the applicants, it has been held that if the NPA notice does not provide the requisite details, it may be quashed. But in this case, all the required details are there in the notice, and as such, the judgments cited by the applicant are not helpful to them. So 13(2) also upheld. Now, what they have pointed out, in my writ petition, I have said, this is maybe a mistake, but on record, a 13(2), earlier there was 13(2), thereafter some payment made, then again, my lord, the negotiation is going on, then subsequent 13(2) notice has been issued. That 13(2) notice is subject matter in my application under section 40. But here, previous 13(2) application has been pleaded and annexed. That is, if that is fault, that is a fault. Not, my lord, goes to the root of the matter, whether there is any 13(2) notice or not.
And that is not a suppression because the DRT order records that. Page number 21.
And yes, my lord, is correct, my lord. Kindly come to page 21. Yes. Kindly come to paragraph 5. Briefs of the facts they are written there of the court. Here, my lord will get it. Last 3 lines of paragraph 5. But later on, Admiralty got it. Later on, again 13-2 notice was issued on 18 January 2021, followed by possession notice under dated 20th July 2021, which occasioned filing of essay by the applicant under section 17 on of the SARFAESI Act. This was the subject matter of section 14, my pendency of my 14.
Position notice to
Yes.
that's what it is.
And the your lordship, in the middle of that paragraph, your lordship will find the in the writ petition this 13-2 notice has been triggered and annexed.
Yes.
30th June.
May I have minors?
Reply.
May I have minors? Kindly leave that I've just come.
I am in reply. 30th June 2014, my lord has got it.
Is a date of NPA, paper page number 17 में चले जाओ.
And your lordship now kindly come to page 17. This we have annexed, but the
So 18 এ গিয়ে date of NPA টা দেখিয়ে দিন যেটা ম্যাচ করছে.
13-2, my lord has seen that. Now kindly see the date of NPA. Your lordship will get at next page, paragraph 3.
2014, which is recorded in that order.
With effect from 30th June 2014.
Which is there in page number 21.
That is page number 21, but earlier I have shown to your lordship.
A position notice টা এই যে 8/1/2000.
So my lord, in my humble submission, what is left out to be argued before my lord? And if my lord is invited to decide this point here, which is to be decided on the basis of the evidence by the lower appellate court, lower cannot say now, the tribunal, appellate tribunal, then that will be infructuous. And that your lordship certainly cannot do under Article 226. When, my lord? Now I will show to your lordship. So facts, so far as facts are concerned, my lord, that's all. Nothing more I will address in my writ petition. My lord, here I will cite 2 judgments for your lordship consideration. One is, what is suppression? 2004 7 Supreme Court cases 166. It is off-quoted judgment. Off-quoted judgment. Your lordship has used it so many times. 166. Kindly come to paragraph 13 only. I will not travel in
Suppression of only material facts.
Now I will consider what are the material. Paragraph? Paragraph 13. 13. 13 and 14. My lord, repeat it. What is the material fact? I start with this. That you are saying that your section 14 is not maintainable. That's why court should not direct the authority to consider and dispose of my application under section 14. So you have to demonstrate before my lord, if allowed to be deposited. I say you cannot, you have no say. Particularly the SARFAESI matter, you have no say forward. You have to say that these are the suppression which goes to the root of the matter, which are material. I have shown to your lordship, NPA decided, 13-2 decided, everything decided. And mayor's voice was that there was a suppression of tenancy in the property. That according to my humble submission, subject to my lord's pleasure, that there is no clause in 9 that you have to disclose who is in possession. There is no such disclosure. Actually, ask you
they have at time of sanction sanction they have appointed evidence by saying that property is free from all income.
আমার দরকার news. আমার তো দরকার. Now, my lord, the another judgment, my lord, I want to rely. This is unreported copy there. Binoy Chaudhary versus AU Small Finance. No, this is not prior to my lord's elevation, so my lord may not be knowing this. My lord, kindly turn to page. 2 things I will show to your lordship from here. Paragraph 11. question was paragraph 11. Sorry, my lord. Yes. This is all settled law, but when lawyers appear, well, sometimes some settled law, we has a bad habit of citing a judgment. The section mandates that any application by the
Paragraph, Mr. Paragraph
11. The section mandates that any application by the secured creditor shall be accompanied
sir.
by an affidavit duly affirmed by the authorized officer of the secured creditor with a certain declaration of 1 to 9. Now, my lord, kindly come to when paragraph 13, when Nobel Kumar is affirming.
This all of this was, at least for this court, it was settled by Jawahar Singh. Jawahar Singh, lots of writ petitions were there. I was also a party there. I mean, appearing for one of the banks.
Now,
it was
what it is saying, only this part I am relying on. Kindly come to paragraph 13. Nobel Kumar is confirming a judgment of 2007 Criminal Law Journal of Bombay. What is saying? It is saying CMD DM acting under section 14 of the NPA Act is not required to give any notice either to the borrower or to the third party. So if there is
later on reiterated in Ramakrishna Baltarle.
it is all
later on.
So if the statute by a pronouncement of judgment contemplates not to serve any notice, then mayor, the petitioner has added or court has added a party, he has a right to say. I am asking this question to myself. He has no right to say anything. These are the two judgments, my lord, I want to rely for your lordship's consideration. And
judgment is distinguished forever.
My lord, now that's all. I will not take many money in my matter. Now, my lord, they have relied on 2008-12 SCC.
Page 481.
Page 481.
Suppression.
Yes. If it is suppression, it goes to the root of the matter. No doubt about that. Paragraph 34, they have said that. Now, my lord has to come to a conclusion. First, whether there is a material suppression. So, this judgment, without being the facts, cannot apply in this case. Now, my lord, should I... now, the second matter. Second matter, I have argued, my lord, there is no pleading, there is no fraud pleading. That, my lord, one. No malafide allege. Only pleading is that I paid the money, I want money back because possession could not be taken. But it could have been decided long back. Immediately the 14 application has been decided. But suppose today he is challenging the sale. Now he is effecting the sale. Today, if the sale is set aside, what will happen? Bank will get the possession, will get another buyer. How he is prejudiced? Unless his section 17 application says that NPA is erroneous. If 13.2 erroneous, again 13.2 can be granted. Only in case of NPA, this proceeding will go. A fresh proceeding, if NPA is there, can be invoked. So far as Mr. Bhattacharya's matter, what borrower can say? He is saying the suppression. Suppression is beneficial for him, if at all. If at all there is suppression, it is beneficial for him. Property will be less valued, higher value. Mr. Bhattacharya's client has purchased the property unencumbered. So it is beneficial for him. And either way, my lord, the borrower has no say in this proceeding. That's all. Any other query from my lord?
No.
I will take 5 minutes.
No,
There's the admission during the proceedings, Your Lordship. It has been suppressed. The truth has to come to light. That's the duty of the court as well as the proceedings. I have categorically stated in my petition that because of your declaration under the rules I have purchased. Now it appears you cannot hand over because that is property encumbered. This is really, my lord, a fraud.
Sorry, my lord, nowhere said. Only on the ground of property encumbered, he is unable to hand over. Let us test.
You are unable, not I am unable.
No.
But
We
therefore,
cannot be handed over because of the encumbrance. Can you see the pleadings? Mr. Bhattacharyya should not say anything from the bar.
this is fraud on statute. Because the public authority who have been empowered by the law has to be truthful to the powers of exercising the statute. And this is well settled principle of law. I don't have to cite authorities. That when there is a fraud on statute, I don't have to allege anything against any individual. That will be apparent from the proceedings before the court. And duty of the court, I have referred the judgment, Lordship must have gone through it, is to find out the truth.
সব বলা ছিল, সব দেয়া আছে। এটা ছাড়াও তো আরো 4টে কথা।
Now, admittedly, before my lord, during the proceedings, the truth has come that the property could not be handed over to me in spite of my payment the entire money. Why? It now seems that the proceedings between the borrower and the bank. Why should I be kept, my lord, waiting behind the screen and suffer, my lord, the pecuniary penalty?
Duality admitted হয়েছে।
And that's why, my lord, to be pleased to see in many matters, lordship has looked into it. The purchaser should not be put into difficulty. The bank will be free, let my money be returned. I don't know. I am not having nothing to do with the property. Because I have already suffered, I have suffered time, I have suffered money, I am suffering because of their latches. But that being the consideration, Lordship has seen the judgments which even my lord had referred to, that the role of the auction purchaser and how it should be put into in oddities, this much I can say, Lordship. These are my submissions, nothing more. Because I have categorically stated.
Ask the state to see what happened.
That is
your instruction.
The things which are well known to the court, I never refer to them. They show the rules are known.
You know, কত কমে গেছে।
Now,
Yes, my lord is closing that matter, my lord CAB. My lord, only things is that my learned senior friend has cited the judgment. My lord, in paragraph number 13, my learned senior friend has cited. My lord, please come that paragraph number 13. Now, just 2 minutes. My lord, only one sentence I will read and we will close.
আমাদের ম্যাটারে
পড়ে দে। হ্যাঁ।
Which judgment? Which
Suppression, material
2004
suppression. Material suppression.
Yes.
Just nothing. My lord, 2004 SCC 7. My lord, paragraph number 13, word starting with as a general rule. My lord, this is properly and seriously indicated about that, my lord, income tax. And that the my lord, one legal maxim, my lord, we can remember that generally a specialibus non-derogant. SARFAESI Act is clearly special act. It is not applicable here. So this is not applicable at all. And this judgment, your lordship, that is a general law. My lord, it is always accepted. So
Mr. Bhattacharya and Mr. Basu, I will keep this once on Monday. I may have some queries. If
Yes.
I don't have, I'll close it.
At Monday.
Monday or Tuesday, Monday থাকবো না।
Oh, but Tuesday.
Tuesday একটা রেখে দিন।
But like hearing is concluded.
Then what is the benefit of going there? If again now to read, brief in the table, in the chamber, what is the benefit then?
But he is trying to define the post.
My lord, I mentioned in the morning item number 31. I brought my other side, my lord.
Party number 1, my lord. May I file my
We are filing our notes of argument, my lord.
right, note
31.
note?
Just take the notes of arguments and.
Special list में नहीं, 31
The detailed notes I'll just take on record and call your matter. 31.
Oh, yes. I just handed over to my lord. My lord, our interim order is expiring 31st August.
Till disposal.
Till disposal, my lord.
Wait, 37 have been typed. Without annexure, এটা একটা দিন।
I'll keep it one more day because lot of matters were there.
But the arguments were closed.
Yes, but
Yes, any.
maybe I need some clarification. I haven't formally closed it here. এটা 2 p.m. করে দিন 2 p.m. at 2 p.m. হ্যাঁ item 31 at 2 p.m.
না
আমাদের টাইপের
সবুজ কাগজে
এটা কি
I'll get to this after the 2 p.m. Yes.
The Lordship had kept it for filing notes of arguments.
And
Only one thing.
I have not closed it as yet.
What we have also done is, my Lord, Lordship will remember that my friend relied on the counterclaim filed in the arbitration proceeding. My Lord, I had said that, my Lord, we will disclose the, my Lord, the statement of claim. My Lord, if your Lordship goes through it,
another day, Lord, I've given my notes.
my Lord, let me also give my note. My Lord, your Lordship will kindly consider it. Then, my Lord, we'll come back next Friday.
Next Friday is a holiday.
Oh. Then whenever your Lordship directs, well, may I just hand it up? Your Lordship can keep it.
5 minutes.
If your Lordship has any queries, we'll just answer that.
Now, I had to, Lord, deal with. Basically, what I wanted to do is, Lord, take your Lordship through the note, which is a summary of my argument. So, Lord, if your Lordship takes it, sees it, Lord, then I'll come back any day, 2 minutes.
Well, what we'll do is,
Lord, we'll take an adjournment.
October.
It's in October.
well, it's in October.
October. Yes. Lot of time, Lord. In any case, we can take an adjournment. There's no problem.
Well, let me also hand up my note, my Lord. I have annexed the statement of claim. Exchange করতে হবে নাকি?
I want to see what you have written.
No, I won't show you.
Yes, 120. very innocuous spread. My lord, kindly have a look at.
I am for the state.
Bank was served. Yes, my lord, it has to be. And if you can't produce that,
I mailed you, served by mail.
well, the Bank of Baroda, my lord, is at Bankura. So we mailed them. It's difficult. I understand if somebody is on line or something, my lord. If your lordship sees 171, now in the meantime, what they'll do is, my lord, they will go and take away, my lord, my possession. And my entire endeavor at DIT, my lord, will be infructuous. My lord knows that. My lord, there were 2 orders from Justice Krishna Rao in the last determination, my lord, where his lordship only said that I am protecting you for some time, but go back to the DRT and do whatever you have to. And here is a situation like that. And here, my lord, your lordship will see, I'll show your lordship, the matter is appearing before the DRT. My challenge before the DRT, my lord, is I have mailed the bank. I can show your lordship that as well. But if they don't appear today, Bank of Baroda, Dipanjan Datta, yes. For Bank of, he used to appear for Punjab National Bank, even for Bank. Then keeps it at 3 million. I'll give him notice and I'll come back. Very good. Now, Dipanjan Datta ke phone karo. My lord, I'll tell him that your lordship has kept it at 3 million. I'll come back at 3 or 2:30. 2:30, I'll come back. 2:30, I'll come back without saying that. I'll come back at 2:25. 5 minutes. I will not pay for anything else. Just 7 days. Give me time so I can go to the DRT and get it heard. Nothing more than that. That is not a. That I will pray before your lordship so that they can, my lord. Nothing more than that. Otherwise, on 29th it becomes infructuous if my learned friend goes and, my lord, takes over possession.
Scheduled yesterday as a product.
There is
That's the order.
there is a order of the district magistrate under the appropriate provisions of that was
Actually.
passed on 2024. Yes, it is to be implemented, and my lord, for the
They've given us notice.
that I have to take instruction because this is received by me just 10 minutes back.
E205.
My lord,
Lord, have a look at 206 once. 206 একটু জচ্ছার কে দিন 206 দত্ত দীপাঞ্জন দত্ত আরে সেক্রেটারি অ্যাডিশনাল সেক্রেটারি This is given on 14th of August 206. আর আমি কবে ফাইল করেছি একবার বলো বিফোর দ্য ডিআরটি
Pending since 2024.
And my lord,
Expedition was just one. In 2026, that is also not done.
First.
then my lord, we file an application then into 2024. যা দীপাঞ্জন দত্তকে খবর দাও
I'm appearing for 3 and 4, respondent number 3 and 4. Mr. Choyan Gupta was appearing. He has some difficulty today. Can be taken.
I am for the petition.
No, this is my lord, the almost my lord completed.
Maharaj, Mr. Shambhudu Datta is appearing for the petitioner, Maharaj. Maharaj, it's coming, Maharaj.
Item 20, 11, 20.
Please.
I do not know whether I should start, Milord, because this is that Calcutta Club matter on Entertainment and Luxury Tax Act, Milord. We have served, Milord. We have served, but yes, Milord, it was, Milord.
Mr. Surjanil Das, learned AGP is appearing in this matter. Mr. Surjanil Das, learned AGP is appearing in this matter for the state. My lord, I'm placing for short pass over, my lord. Yes, sir.
Lordship. Grateful. In that case, Milord, may I pray for a not today, or should I come back, Milord?
My lord, keeping it not today.
Great. Very deeply obliged.
May it please, my lords. I am for item number 35. I am for respondent number 3, my lords, in this matter. This petition pass.
Lordship,
But again, my lord, I am for the opposite party. Very.
Lordship, 41, I am appearing for.
affidavit service, sir.
Affidavit service. 29. My lord, last occasion, lordship's order, kindly see. Last order. Order dated. Last order. January. First copy has been served.
Lordship, report has already been filed. It's in the record itself. Let him make his submission, thereafter I will.
Annexer P16, my lord, page 16, Annexer P1.
Page 16.
FIR. Page 16, first FIR. Page 19, continue inner page 3. During I repeat, sir, man. Annexer P1, FIR. First information report. Thereafter, page 18, page 2, serial number 4, Oloka Manna, wife of Kajol of Chandabila. Thereafter, page 19, page 3, Oloka Manna, wife of Kajol, Kajol, to a cause under section 147, 48, 49, 448, 383, 186, 307 IPC read with section 25 and 27 Arms Act and 9 MPO Act 2023 PDPPC Act may be started against all the arrested person and unknown witness. SIPK Basu is directed to take up the investigation. Thereafter, final charge sheet. Final charge sheet, page 20, Annexer P2, page 20, P2, charge sheet. Charge sheet has been filed by the concerned police officer and page 22, inner page 3, middle portion. During investigation of the case, myself draw up a rough sketch map of the PO and made in index, examine injury police person and available witness and mark their statement under section 161 CRPC, seize the weapons under proper seizure list duly signed by the witness. During investigation of the case, it reveals that some members of Maoists were arrested by joint force of Chandra. The arrested person brought to camp. On the other hand, some squad member of Maoists Assam village under the banner of Jono Sadharan Committee and forwarded advance them to Gherao the camp, and the Maoist group then attacked the camp and started away their members and looted away the arms and seized of the camp. The members of the move knowingly Gherao the camp and the help and read arguments of Maoist, the move through stone to the police and due to the injury came to dismantle the administration and also change the same administration. They were 500, 600 is members of the Assam different distance village. The premises case under section 147, 148, 149, 448, 353, 186, 307 IPC, 9 MPO Act 25 and 27 Arms Act. Kindly, final charge sheet has been submitted. Charge sheet number 44 2010 dated 31st January 2010, and thereafter, my lord, P3 page 25, date of arrest 20 September 2009 and date of release on 15th October 2009. When any mistakes came, my lord, page 7, paragraph 9 of the writ petition. Page 7, paragraph 9, that your petitioner state that in the year 2011, the said ruling left from government is changed and the present ruling government has come into force and the Chief Minister of the West Bengal government took the policy decision to provide the job to the members of the Maoist squad and also the victim of the family of Maoist squad. Accordingly, the accused Maoist members are surrendered themselves and arrested. Maoist rehabilitation activities are provided for the job of special home guard, civic voluntary, etc. under the policy decision adopted by the government of West Bengal. Thereafter, paragraph 10, my lord, that your petitioner state that accused of the aforesaid criminal case connection with aforesaid Kotwali PS case number 277 2009 dated 20 September 2009 under section 147 and such section read with section 25 27 Arms Act and 9 MPO. Thereafter, provided job against the post of special home guard, civic voluntaries, etc. by the force of the said government policy, except the petitioner without showing any proper reason. Thereafter, paragraph 12. That your petitioner state that your petitioner has submitted the representation before the respondent authority on 1st October 2021 for engagement her against any job as per scheme declared for the Mousis who surrendered and were arrested, the suffer jail custody and release on bail. But till date, the respondent authority have not taken any step to ask the petitioner to appear before the appropriate authority. This senior application. The respondent learned government leader also submitted the report. Before your lordships. First report. In the first report, the authority or district superintendent of police admitted the fact.
I was not informed about this one. Yes, understanding counsel. Understanding counsel. Item numberটা কত ছিল? আচ্ছা।
Copy service right?
Yes. দিদি আইটেম নাম্বারটা একটু বলুন না। আচ্ছা আচ্ছা হ্যাঁ মানে অ্যাডভোকেট কে ছিল? আচ্ছা আমি দেখি, ঠিক আছে।
Whether that report is supplied to my learned friend or not, I do not know. But report submitted.
I have the report. Copy of the report. There are two reports.
There are two. In the first report, my lord, it is admitted that the petitioner was arrested for Maoist activities and police case was started against her and she was arrested. She suffered the jail custody. And on the same footing, another two persons was also appointed to the post of Home Guard as per notification or adopted policy taken by the government of West Bengal. That in the first report, my lord, it is clearly stated that the two persons, namely in the district of Paschim Midnapur, arrested in the same case, also have got the benefit of that adopted policy and they are appointed to the post of Home Guard. Our submission is that on the same footing when one person has got the appointment or has got the benefit of that adopted policy, this writ petitioner, being the same person, cannot be deprived of getting that. This is discrimination. This is discrimination. Therefore, her representation should be considered in accordance with law as per Article 16 of the Constitution of India as well as Article 40. This is purely discrimination. Now, what is my learned friend's submission? I do not know. Kindly allow him to make submission with regard to this point whether discrimination has been done by the district superintendent of police, and even from this report it is also appeared
that her representation was not disposed of, not considered after giving her an opportunity of hearing. In second report, kindly see that those two persons who are appointed to the, who have got the benefit of that adopted policy, getting appointment to the post of Home Guard. May I kindly see their status? That is the same, on the same footing. And in that report, my lord, there was, my lord, only one application submitted by them, by those persons who are on the same footing, that they filed an application before the district superintendent of police. That is, my lord, at page 29, that they have surrendered themselves before the DSP and DSP considered it. But they have not done any kind of, they have not made any kind of representation to the district superintendent of police that our representation should be considered, and we have also taken part against the said Maoist case, also against the, this is the case. This is the case under MPO Act and PDPP Act. Public protection. Prevention of damage to public property. When prevention of damage to public property and some persons assembled with the deadful weapons and called as the Maoist active members, and they are arrested, and when the government adopted policy also has given to those persons the benefit of that policy, therefore this petitioner is entitled to get that policy, to get that benefit of that adopted policy.
So, my lord, what is the prayer of the petitioner? A writ in the nature of mandamus commanding the respondents and their men and agents or subordinates and each one of them to provide special job to the petitioner as per amnesty scheme for Maoist rehabilitation in West Bengal pursuant to the representation of the petitioner. My lord, petitioner's claim is that she had been a Maoist and as such claims a job under the scheme, which says that the members of the Maoist squad and the accused Maoist members who surrendered themselves or arrested for Maoist rebellion will be provided job under the said scheme of the government. However, my lord, if your lordship kindly pleases to take the supplementary report filed in your filed by the additional SP Shotam Banerjee in pursuance to your lordship's order dated 9th January 2026. My lord, the second one, I'm for your lordship's convenience, I am reading the relevant portion, page 8. After that, the relevant, has your lordship got it? Page 8 of the report. After that, no such intelligence input collected regarding the involvement with the live activities through crime offense against state, service activities against the security forces. Therefore, the prayer of the writ petitioner seeking for job under surrender cum rehabilitation scheme of left-wing extremists in the affected states or such government scheme was not processed at that time, because they are claiming that the petitioner belongs to the Maoist category. But so far the report of the additional SP is concerned, she doesn't belong to the Maoist. Well, 11th of the next month.
Let it be parted.
As
Okay.
Roman Kumar Roy for the state.
This is my application. If your lordship kindly takes
There's
the
a
application.
counterpart. He mentioned it. Got it fixed at 2:30.
Yes. And thankfully it worked because otherwise there was 3:30 again today. But this is an application for return of the plaintiff because the agreement on the basis of which they filed this suit, my lord, has a forum selection clause. And they have themselves disclosed it, so there is no question of any evidence coming in because it forms a part of the plaint. I just need to show that to your lordship. Now, if your lordship kindly takes, my lord, before my application, if your lordship takes in that only, page 11 is the plaint. That's
11.
where the plaint starts, page 11 of the application.
Page 11, yes.
Now, this is the plaint. Kindly sees it's filed by one Siddhi Vinayak, which is the plaintiff, and the defendant is Britannia Industries. Now, kindly takes the first paragraph itself, the purchase orders. So, basically, this particular suit has been filed on the basis of 10 purchase orders. Now, kindly see the averment. The purchase orders are standard form contracts. Plaintiff does not have the option to negotiate the terms therein. Then kindly sees paragraph 2. During December 2024 till March 2025, the plaintiff received 10 spot purchase orders by using its vendor code for the supply of a total quantity of 6,000 quintal. This is of sugars. They've not written. Basically, it was supply of sugar crystals, which was the subject matter. Now, this is their averment of the plaint. Now, if your lordship kindly now comes to paragraph 3, the supplies were made at various places, including such and such. So, West Bengal also they've mentioned. And kindly see, and Karnataka is also there, very important, because the forum selection clause is for Bengaluru, Karnataka exclusive. I'll show it from the purchase orders itself. Now, copies of the 10 purchase orders, starting from PO number 21006, 5641 to PO number 21006, 7664 are annexed here to and respectively marked A to A9. Now, my lords, what I have done is for the convenience of the court, my lord, it's already annexed to the plaint, but just I prepared a chart with indicating the clause numbers also with regard to the forum selection clause.
Thank you.
Now, this is your lordship. These are the pages from the petition itself. The clause is clause number 23. And these are the respective pages your lordship will find it. Kindly takes the first one, which is clause number 26 is at page 23. Kindly comes to page 23 first.
Page 23.
At 26, your lordship will get clause 23 at page 26. Now, what I've done is I've enlarged it also for your lordships. If your lordship kindly takes a copy of this, it's easier to read.
Thank you.
So, if your lordship sees clause 23, jurisdiction. Any dispute arising out of or in connection with this PO shall be subject to the exclusive jurisdiction of Bangalore courts. Has your lordship got it?
Yes.
Also, if your lordship kindly marks this other clause which is there, which is 25, which will be very important also, because they've tried to make out a new case, but I'm just placing it for the time being. Supersede. Except for cases where a separate formal agreement has been signed between the parties, this PO cancels and supersedes all other proposals, terms, negotiations prior or kindly mark subsequent discussions, understandings, arrangements or agreements made prior, parallel or subsequent to date thereof, whether oral or written, including the invoices raised by the suppliers, service providers with respect to the transactions envisaged hereunder. So this is the sole repository. This will prevail over any prior or subsequent things. Now, apropos this, now if your lordship just comes back to the plaint, which was starting at page 11, I had placed paragraphs 1, 2, and 3. Now, if your lordship kindly sees, their case is that they have supplied sugar in terms of those POs, but we have not paid them the money. This is their case. They've given a chart, kindly comes to paragraph 12, where they have totaled this amount, and also your lordship will find the averment which is there at paragraph 14. What is the dispute about? Why it's a commercial dispute according to them? The dispute arises out of goods sold and delivered and services provided under contracts. Very important. Under contracts. So they accept that this is a contract between the parties. On this basis, goods have been supplied and they say it has not been paid. Now 15 is their averment. The defendant has its registered office within the ordinary original civil jurisdiction. And kindly see, they know that there is a forum selection clause, and that is why paragraph 15. And any contrary jurisdiction mentioned in any standard form contract and or purchase order has never been accepted by the plaintiffs. Well, they have supplied on the basis of that. Part payments have happened on the basis of that. And now they want to renege from that, but just to wriggle out of the forum selection clause. Now, the law is very clear that today, while deciding an application of this nature, your lordship will look at the plaint and the documents annexed to the plaint. I need not go any far. So, my lord, there is a clear-cut forum selection clause, my lord, which, my lord, a person has to, my lord, on that basis, it has to be done. And now, my lord, this standard form contract, I did not get an opportunity to negotiate. My lord, this issue is no longer res integra. My lord, there is a recent Supreme Court judgment where, my lord, the Honorable Supreme Court has said, look, you can't take all this. A contract is a contract. Whether you had superior bargaining power, less bargaining power, once you've accepted it, you've acted in terms thereof. There is no question of you now saying that this cannot be done. And if there is a forum selection clause, you'll have to stick to it. This being the position now, my lords, more importantly, another glaring thing, this being a commercial suit, my lord, kindly takes, my lord, the verification of the plaint. Kindly comes to page 17. My lord, the verification is by one Rohit Agarwal, residing in such and such. So he is, my lord, not even an employee of the plaintiff. Plaintiff is at a different place altogether. He is not even an employee. He files this plaint. And my lord, kindly see in what capacity. He says he is an authorized representative. Now, my lord, this entire thing with regard to authorized representative, my lord, has been deprecated by our own High Court. My lord, and an appeal in a similar matter has been dismissed on this very basis. I'm relying on, if your lordship takes 2017 SCC Online Calcutta 8191. Copy the other also. But kindly takes this. There also a similar thing was stated. Now let's kindly see, it's a short judgment of a division bench. Now let's kindly see. The order impugned does not call for it, particularly since no serious prejudice has been occasioned to the appellant. Herein, upon the plaintiffs obtaining leave to withdraw the suit filed in this court with liberty to file afresh, then principal grievance of the appellant is that the appellant was not given any notice of the application by which the plaintiff sought the withdrawal of the suit with liberty to file afresh. In fact, oral applications are sometimes entertained on such count, particularly when formal defects in the plaint or in framing of the suit are cited. In this case, however, the appellant appears to have refused the writ of summons. The appellant claims that upon a defendant refusing, my lord, then that part is there. Now, my lords, kindly turns around, kindly sees paragraph 3, my lords, what is relevant to our case. Apart from the several grounds on merits that have been considered in the order under appeal, the trial court found that the application filed by the appellant herein for recalling the order by which the suit was permitted to be withdrawn and a fresh suit was allowed to be filed was verified by an affidavit affirmed by an authorized representative of the appellant herein. Well, exactly like our case. An authorized representative.
We'll take it up at around 3:15.
The only thing is the next date fixed is on 11. If your lordship so desires, can direct me not to take further courtship till 11. And in the meantime, they may take appropriate steps in the DRT. Only that part.
At they come at 3:15, 3:20, I'll take it. Till such time, let them continue. Yes. Yes.
An authorized representative may deal with matters pertaining to the relevant company and its bankers, but an authorized representative is not any species of personnel permitted to verify pleadings on behalf of a body corporate. My lord, exactly that has been done in our case. And my lord, on this, since this very application, my lord, was incompetent, nothing further need to have been looked into in such and such and dismissed. This is one. Now, my lords, more importantly, they've done the same thing. They filed, my lord, an affidavit in opposition to our application. Your lordship kindly takes that affidavit in opposition, same thing. Oh, reply file. Reply to the other.
Preempt them. Friday.
So, my lords, this is first, my lord. Now, my lords, more importantly, your lordship will take the frame of the suit into consideration at this stage and nothing beyond that. So, if your lordship takes the plaint is really small. Now, if your lordship, I'll just now go back to the plaint once and then I'll come to the relevant law on the forum selection clause. Now, if your lordship kindly comes to that page 11 where it starts, my lord, let's understand, my lord, what is the construct of the plaint also. My lord, it says the plaintiff is an established vendor and supplier of sugar crystals to the defendant and has a unique vendor code from the defendant, which is such and such. By using this vendor code, the plaintiff can access spot purchase orders offered by the defendant. Then, my lord, the purchase orders are standard form contracts. Plaintiff does not have the option to negotiate the terms therein. Now, my lords, this is the period also is mentioned during December 2024 till March 2025. The plaintiff received 10 spot purchase orders by using its vendor code for the supply of a total quantity of 6,000 quintals. My lord, this is the subject matter of the present suit. Now, kindly see, based, my lord, this is very important. Based on these purchase orders, the plaintiff supplied an aggregate amount of. So he acted in terms of these purchase orders. So, my lord, now it no longer lies in the defendant's mouth to say that no, this purchase order is not acceptable. Because he has acted on this basis. Based on these purchase orders, the plaintiff supplied an aggregate amount of 42,816.96 quintals of sugar crystals. Plaintiff received the price. Now even it has been part payment has also happened. According to them, the plaintiff received price of 27,338 quintal of sugar crystals supplied by it, leaving the price of 15,478 quintal sugar crystals worth rupees 589. Well, this is their case. The plaintiff also provided transportation services, etc., to the defendant on the written request in terms of, kindly sees again. So they are again categorically relying on the purchase order. In terms of the purchase orders and written request, that is email dated January 15, 25, the plaintiff generated respective tax invoices and e-bills to complete the supplies and transportation. So again, everything on the basis of the purchase order. Then Malaj kindly sees paragraph 3. The supplies were made at various places in Karnataka. Very important. Orissa, Tamil Nadu, West Bengal and Bihar. Copies of the 10 purchase orders starting from PO number such and such to such and such. My lord, I have given your lordships the page numbers of the PO. My lord, your lordships will match it with the chart. All the POs are there with the relevant forum selection, identical clause which is there. Now, my lords, kindly sees. The defendant has given due credit to the unpaid invoices by deducting TDS at 1% on the supply of sugar crystals and 2% on the transportation services as per statutory deduction. Then copies of 52 tax invoices, e-bills from the period of such and such are annexed here too. So, my lords, they disclose all that, copy of the chart. Then, my lords, they say the aggregate value of the said goods and services is rupees such and such. They quantify the amount. The defendant has accepted and acknowledged the supply of sugar crystals and transportation services. Now kindly see 6. Very important. The defendant was under the contractual obligation. So they are relying on the purchase order to make payment within 3 days from a date of receipt of the goods and transportation services. The defendant has repeatedly failed and neglected to make payments. By emails dated such and such, demands were made. Upon receiving emails, has acknowledged its debt, not made payment. Copy is disclosed. Plaintiff states that contractual dues, very important. He says contractual dues to have been paid by the defendant within 3 days from the date of receipt or supply due to the defendant's contractual breach. Breach is also contractual. For not paying rupees such and such within the plaintiff has suffered substantial loss. Paragraph 9, my lord, high volume, etc. Then they do the calculation for interest, etc. Then, my lords, they come to continued compensation. They say, again, my lords, in paragraph 10, they categorically mention contractual dues. And paragraph 11, your lordship sees, the plaintiff thus continues to suffer the loss due to breach of contractual dues by the defendant in not making payment of the dues owed under the purchase orders. Well, very important, under the purchase orders. And email dated January 15, 2015, that due on account of loss of profit and damages has naturally arisen in the usual course of things as a result of contractual breach. In the above circumstances, the plaintiff is entitled to claim money. Now, here they quantify. Then, cause of action is out of this particular contracts. My lord, kindly see paragraph 13, which I had shown. Now, para 14 is what he says is under contracts that have not been paid. Para 15, my lord, is the jurisdiction, my lord, because they knew there is forum selection clause. My lord, obviously, my lord, this was not, no clause 12 was also required because they showed Britannia has its registered office within. So, my lords, before it was filed in regular course without pointing out because they knew that this problem would come with regard to forum selection, and that is why this averment in paragraph 15. But my respectful submission is, my lord, because they've acted on it, my lord, today there is no way that they can renege out of this. My lord, they can't, my lord, today say that, this contract or purchase orders are not binding on me. Now, my lord, on that basis they've played. My lord, we have immediately taken out, my lord, application for, my lord, return of plaint on the basis of these averments. I need not go anywhere else. My lord, there is also a suit pending between the parties which I have filed, which is also the subject matter of Bangalore court, where I have filed a suit. Because, my lord, the dispute involved a lot more contracts. There was also another contract, etc.
Bangalore suit, this PO is also.
Yes, yes. This is the subject matter out there. This is also the subject matter out there. My lord, same POs are also the subject matter out there.
That's the prior suit.
No, this is the prior suit. That is the subsequent suit. That is the fact. But the fact is, because of the forum selection clause and the other agreement which is there, both has Bangalore jurisdictions. That is why that suit has been filed within that particular. Because my lord, parties have chosen a forum themselves, knowing well where they have to go.
They have put in the written statement there.
No, my lords, not yet. Written statement has not been filed. Not filed. Not filed. They have filed an application for stay. My lord, now because why they have filed 10? Because also, my lord, they are accepting that the same POs are the subject matter. That's also very important. Okay. Now, my lords, if this is the position, now, my lords, kindly takes their affidavit in opposition. What case they've tried to make out in their affidavit in opposition. My lord, like I said, my lord, this affidavit of opposition also, my lord, your lordship should not take into consideration for the same reason, because it is again, my lord, by that same, my lord, authorized representative. My lord, kindly takes paragraph 1. Same Rohit Agarwal, I am the authorized representative of the plaintiff. Then, my lords, kindly sees, I have read a copy of the petition said to be affirmed by one such and such. Now, my lords, kindly sees their case. I say that a pleading qua the plaintiff has stated only material facts in a concise form on which it relies for its claim, but not the evidence by which they are to be proved. The plaintiff shall elucidate on the material facts through its affidavit of evidence at the appropriate stage. The plaintiff relies upon the statements. My lord, kindly sees, the plaintiff relies upon the statements made in the plaint and documents sued on. So, my lord, which includes those purchase orders. Now, my lords, the statements made in the plaint should be considered as part of the present affidavit and are not reiterated to avoid prolixity and repetition. Now, my lords, plaintiff has supplied sugar crystals to the defendant as per 10 spot purchase orders. My lord, again a positive statement with regard to those 10 spot POs which has the forum selection clause. Despite receiving the sugar crystals, the defendants had not paid the entire amount. Thus, the plaintiff has a claim for unpaid goods sold and delivered. Paragraphs 1 to 15, the plaintiff has specifically mentioned that all the 10 spot purchase orders, kindly sees, were standard firm contracts and the plaintiff did not have the option to negotiate the terms therein and did not accept the forum selection clause. Well, once he has accepted and acted in terms thereof, well, I can't act in terms of one clause and take a defense that no, I accept the first part of the contract, I don't accept. There is no correspondence to that effect prior to this document saying that I have not accepted this forum selection clause. This is just as an afterthought. Now, my lord, kindly sees, the plaintiff has made supplies and has only performed those terms. So, my lord, he is trying to, make the contract divisible. Kindly sees, has only performed those terms which is agreed, and the same will be evident from its conduct. So, he says he has acted in terms of the particular purchase orders. As far as the forum selection clause is concerned, plaintiff did not agree to the same. There is neither any implied nor any express consent by the plaintiff to the purported forum selection clause. The parties were never ad idem to the forum selection clause at any material point in time. My lord, pausing here for a moment, if my learned friend was not ad idem, when he got the POs, he should have written, my lord, and said that I don't want this contract, I am not agreeable to this. Therefore, kindly send me a revised purchase order with a different clause. They never did so. They, my lord, supplied, they got everything. Now, my lord, to wriggle out of this is just come as an afterthought. Now, my lord, kindly sees. There is neither any implied nor any express consent. The parties were never ad idem. Defendant has its registered office at the address mentioned in the cause title, which is within the ordinary original territorial jurisdiction of the Honorable Court. Therefore, this Honorable Court has the jurisdiction to try and determine My lord, I have an office in Bangalore also. The purchase orders will show my office of Bangalore is mentioned very clearly. My lord, if two places have jurisdiction, parties can always choose, my lord, one of the forums. In this case, that has been done consciously. My lord, today my learned friend can't say that I can come to Calcutta and sue in spite of me having agreed to a forum selection clause. Now, my lord, kindly sees. My lord, PO and agreement both have, my lord, the PO, the spot purchase order in this case has the forum's Bangalore office mentioned. Now, my lord, kindly sees, and they have not disputed that. They have not said so. Now, my lord, kindly sees, the plaintiff also provided such and such transportation services in terms of an email request dated such and such. Now, my lords, this is why I made your lordship see the clause 25, which says all communications before, prior, after, everything, this PO will prevail. That supersede clause. Because now they are trying to make out a new case by this transportation services being separate. Now, my lords, kindly see, this email is annexure C to the plain, was sent by representative. This email has been considered. Now, kindly see, first time a new case. This email is annexure C and was sent by representative to the defendant, to the plaintiff. This email has been considered as a separate contact. It will be contract, is written separate contact between the parties. Through this email, the defendant confirmed and awarded to the plaintiff the transportation services of sugar crystals from such and such. The email contains the specific terms and conditions for availing the transportation service. The plaintiff had to raise bi-monthly invoices which were to be settled within 15 days from receipt. Since the plaintiff had to arrange for the freight and transportation vehicles such and such, after delivery of goods, the e-way bills has to be submitted to the defendant along with the invoices. There is no separate forum selection clause in terms of the email dated 15 January 2025. So new case, my lord, this was not there in the plaint at all. So a new case they tried to make out in an attempt to wriggle out of it. Now kindly sees, the plaintiff has fulfilled its contractual obligations arising out of the transporter in spite of receiving the invoices, the e-way bills the defendant has not paid. Thus, the plaintiff has a claim of such and such. So, my lord, he is trying to now jettison his case. My lord, the main case is the non-payment of sugar with, my lord, transportation, everything together, which is clubbed. Now, my lord, kindly sees, as mentioned above, the defendant has its registered office address, which is within the ordinary territorial jurisdiction. Therefore, this honorable court has the jurisdiction to try, determine the dispute, such and such. Then, my lord, the defendant has wrongfully retained, my lord, this is the 10 spot purchase orders, contractual terms. Now, my lords, they add to the spot purchase order, kindly sees, and the email dated January 15. Paragraph 4, Roman 4. This contractual breach has caused loss of business and profit to the plaintiff. The plaintiff is entitled to a continued compensation. Then, my lord, the same story continues. This is a direct loss. Again, my lord, contractual dues. Therefore, this honorable court has the jurisdiction. Now, kindly see, the plaintiff states that it has united several causes of action. My lord, where is this pleading? My lord, this several clauses of action pleading had to be a part of his suit. There is no such pleading. So obviously now he is trying to, my lord, in an attempt to wriggle out of the forum selection clause, he is trying to, my lord, jettison his case made in the plaint and, my lord, make out a new case. My lord, for that, my lord, I am not here to advise my learned friend for that. Now, my lord, kindly sees, without prejudice to the aforesaid and not admitting, my lord, this is the amount, then has specifically stated, again, the 10 spot purchase orders were standard form contracts and the forum selection clauses were never accepted by the plaintiff. The defendant has not filed written statement and instead has raised the plea of territorial jurisdiction by filing the said petition. The said petition should not be entertained because the defendant raised in its a plea of territorial jurisdiction. So, my lord, I can, my lord, always, my lord, take a ground of, my lord, return of plaint because the statute provides me that right under Order 7, Rule 10. My lord, I need not wait till the written statement. My lord, this statement is also incorrect because, my lord, by this point of time, I had actually put in my written statement. Your lordship remembers, we came with a written statement, filed it, and, my lord, then your lordship had given the direction. My lord, so, my lord, this statement on the face of it is incorrect, that we had not filed a written statement. We have also filed a written statement where that point is taken. So, my lord, this is an incorrect statement ex facie. Now, my lord, see, without admitting the allegations made in the said petition, the plaintiff states that the plea of territorial jurisdiction is essentially a mixed question of law and fact. My lord, pausing here for a moment, my lord, here I join issue, my lord. My lord, it is only a mixed question of law and fact when, my lord, evidence has to be laid. But when your plaint discloses the contract itself, which shows the forum selection clause, my lord, then, my lord, there is no question of, my lord, anything else. Because your plaint case, I'm going by your plaint case. So therefore, it cannot be a mixed question any longer. Now, my lord, kindly sees, normally it is well settled that proper prayer to plead jurisdiction is to take the plea in the written statement and a substantive part of the defense. There is no exception applicable to this rule because the averments made in the plaint does not clearly indicate the plaintiff agreed to the forum selection clause. But by his conduct, he's done everything in terms of the agreement. He can't say that I agree one part of the document, I don't agree on the second part of the document. Then, my lord, kindly sees, in view of the facts, it is submitted, this honorable court has the jurisdiction, such and such, my lord. Then he deals with the paragraphs of purchase orders. Has raided first defendant any presumption of allegation contrary. Then, my lord, paragraph 8, my lord, kindly sees, our suit is also mentioned, which we have filed. So they are aware of that also. Before Bangalore is irrelevant for adjudication of the hence denied. My lord, here they say irrelevant. There they say they filed for stay under section 10. Now, my lords, kindly sees, moreover, for the sake of completeness, is that the said Bangalore suit is subsequent to the present Kolkata suit. So, my lord, they can't take self-contradictory stance. Either it is irrelevant or it should be stayed because the subject matter is the same. The plaintiff has already challenged the maintainably, has filed an application under section 10 for stay of the subsequent Bangalore suit, and the same is pending. It is denied that the learned civil court Bangalore has, and this honorable court does not have the jurisdiction, say such and such. My lord, this is his, my lord, entire written statement. And then they say this cannot be decided as a preliminary application, my lord, under Order 7, Rule 10. My lord, that's his, my lord, entire thing. And my lord, very important, para 14, my lord, everything is according to, my lord, what I understand is true to this person's knowledge, who is not even an employee. Everything is true to his knowledge. My lord, because nowhere they say working for gain at such and such, which is the plaintiff's address. That's not the case. He is a businessman who's staying in Howrah. He makes these averments. So, my lord, this is his case on affidavit. Now, my lords, I am relying on, my lord, this judgment, my lord, of the Honorable Supreme Court, my lord, on 2 counts, my lord. This takes care of the forum selection clause and takes care of, my lord, the point with regard to, oh, this was a standard form contract, I did not have bargaining power, etc., so on and so forth. My lord, if your lordship kindly takes, my lord, kindly takes paragraph 3, where the facts are stated on. The lead appeal rests on a simple set of facts which are as follows. White letter dated such and such, HDFC Bank appointed Rakesh on the post of executive transaction banking group in the wholesale banking operations. Pursuant thereto, Rakesh joined his service at Wholesale Banking Operation and Exhibition Road, Patna. The appointment letter of Rakesh had an exclusive clause regarding reading as under. So, my lord, the clause is stated. The terms and conditions set out in the letter of constitute service applicable to your employment in the bank, and with regard to any dispute thereof, Bombay courts will have exclusive jurisdiction. My lord, in our case, it's Bangalore courts to have exclusive jurisdiction. Now, my lords, kindly sees, service was terminated. Then, if your lordship kindly takes, my lord, straight away, my lord, paragraph 4, the connected appeal to rests on similar set of facts which are as follows. Deepti was appointed as clerk in Lord Krishna Bank, which was merged with HDFC Bank in 2009. while employment agreement dated such and such, Deepti was appointed as an officer in the retail banking branch at Janakpuri, Delhi. The agreement also included a similar exclusive jurisdiction clause as the one in the case of Rakesh. In terms thereof, any dispute between the parties leading to legal action had to be thrashed out in the competent courts in Mumbai. Now, let's kindly sees thereafter Roman 5, the trial court wide order dated 17th April 2021 answered the preliminary issue as to whether it had jurisdiction to try the suit and held that the exclusive jurisdiction clause did not fully oust the jurisdiction of courts in Delhi. Dissatisfied with the order of the trial court, HDFC Bank filed the revisional application before the Delhi High Court, which, as noted above, stands dismissed. Now kindly sees the impugned judgments. The impugned judgments in the lead appeal, after condoning the delay in filing of the civil remissional application, allowed the same on the ground that the courts in Patna do not have the jurisdiction in light of the exclusive jurisdiction clause, and that such a clause would operate in matters of termination of service too, relying on the decision of the Supreme Court in swastik gases. The Patna High Court observed that while the general principle is that the suit could be instituted at any place where a substantial part of cause of action arises, however, when a clause such as the one in the instant case exists, the jurisdiction will lie with the court at the place which has been expressly agreed to by and between the parties. That is the court in Bombay in the instant case. So, my lord, two places have jurisdiction. Parties can always choose one forum as the jurisdiction. Now, my lord, the impugned judgment and order in the connected appeal dismissed the civil revisional application on the ground that Deepti was residing in Delhi, was working in Rohini, Delhi, and the termination letter was served upon her in Delhi, and the exclusive jurisdiction clause in the employment agreement did not oust the jurisdiction of the courts in Delhi. The learned judge relied on the decision of a coordinate bench of the Delhi High Court in Vishal Gupta such and such, while declining to grant relief to HDFC Bank in exercise of revisional jurisdiction. Now the question which was framed, kindly see this is very important. The pure question of law. So, my lord, no mixed question of fact and law. The pure question of law arising from decisions on these appeals is whether the civil suits would have been instituted in courts in Patna and Delhi by Rakesh and Deepti respectively in view of the specific clause in the appointment letters, employment agreements, that the courts in Mumbai would have exclusive jurisdiction to decide the disputes by and between the contracting parties. Well, this has been answered. Kindly permits Mr. Banerjee.
So sorry, I was addressing one of the courts next door.
I was completely
No, not taken. অনেকবার এক্স মক্কেল অ্যারেস্ট তোমারই এক
Kindly grant me to grant.
অ্যারেস্ট
এটা কোনটা হাইগ্রেড
না
মানে ওইগুলি আবার
Lord, sorry, Lord, just Lord, to catch up Lord, with Mr. Lord Rajshudari's submission. So Lord, we say Lord, that in terms of the contract, there's a exclusive forum selection clause. If there's an exclusive forum selection clause, Lord, the law now Lord, starting from ABC Laminate appears to be that you will really have to respect party autonomy and institute before that. It's not a question, Lord, which should only be decided at the end of the suit. It has to be Lord, first decided, because otherwise Lord, the whole purpose is lost. Lord, these are Lord, the three Lord, propositions of which Lord, we all really want to show. My learned friend Lord, has already Lord, shown the clauses and also Lord, the affidavit where Lord, they say it's arising out of that contract. Because his case is, Lord, he says, I want return of my money which I paid. I say I have a damages claim against you because you have not supplied the entire contractual quality. Contract payment. So that is really the issue. But Lord, the question is, it arises out of the contract which is entered into the party, which has, my lord, an exclusive forum selection clause. And in that context, my lord, we were showing, my lord, paragraph 7, my learned friend, my lord, has already placed. Kindly look at, my lord, paragraph 8. Before we proceed to appreciate the rival claims, it would be appropriate to notice the applicable legal regime. Section 28 of the Indian Contract 1872 Ordinance. Then, my lord, 28 is set out. That, my lord, is restraint, my lord, of legal proceedings. Then, my lord, paragraph 10 is also important. Refer to section 20 of the CPC, which is reproduced here under. Then, my lord, section 20 is set out. I'm not reading them, my lord. It's not necessary. Then, my lord, paragraph 11. This is the umpteenth time that this court has been called upon to deal with a clause in contracts restricting adjudication of disputes exclusively to the jurisdiction of a court of a party's choice, not disagreed by the other party. In fact, the principles pertaining to institution of suits and the jurisdiction of the courts in a case where the parties have by agreement conferred jurisdiction on courts at a particular place have been laid down by this court in numerous cases, which are entirely consistent and have not required a relook. A perusal of a couple of these decisions may not be inapt for a proper decision on these appeals. Then, my lord, paragraph 12, quote in Hakam Singh and Gammon. My lord, this is, my lord, one of the first cases. I'm not reading that. Then, my lord, kindly come to paragraph 13. It is now a decade later, another coordinate bench had the occasion to deal with a similar exclusive jurisdiction clause in Globe Transport versus Triveni. One sentence in paragraph 3 captures the essence of the law, reading as follows. It is now well settled that it is not competent to the parties by agreement to invest a court with jurisdiction which it does not otherwise possess. But if there are more than one forum where a suit can be filed, it is open to the parties to select a particular forum and exclude the other forum in regard to which one party may have against the other under a contract. Then 14, a few years later, came the decision in ABC Laminate Private Limited versus AP Agencies Salem. Court held that from the foregoing decisions, it can be reasonably deduced that where such an ouster clause occurs, so it's really an ouster of jurisdiction, it is pertinent to see whether there is ouster of jurisdiction of other courts. When clause is clear, unambiguous, specific accepted notions of contract would bind the parties, and unless the absence of ad item can be shown, the other court should avoid exercising jurisdiction. As regards construction of the ouster clause, when words like alone, only, exclusive, and the like have been used, there may be no difficulty. Even without such words, in appropriate cases, the maxim expressio unis exclusio alteris, expression of one is the exclusion of other, may be applied. What is an appropriate case shall depend on the facts of the case. In such a case, mention of one thing may imply exclusion of another. When certain jurisdiction is specified in a contract, an intention to exclude all others from its operation may in such cases be inferred. It has therefore to be properly construed. Now, in our case, of course, they use the word exclusive as well. But it has seen that clause 23. Yes. Any dispute arising out of or in connection with dispute. So even that clause is very wide. Arising out of or in connection with dispute shall be subject to the exclusive jurisdiction of Bangalore courts. So arising out of or in connection with. Now, my lord, will recall, my lord, Renu Sagar, my lord, for the first time used that, which, my lord, in fact, they had introduced, my lord, the concept of when, my lord, 1940 Act did not have, my lord, that section 16, whether you can decide the jurisdiction of the arbitrators. Because of Renu Sagar, my lord, saying very wide, they said very well the arbitrator also can decide his own jurisdiction. That's, my lord, the first time they interpreted it, saying it is very wide. Now, 15, in Swastik Gases Private Limited, a 3-judge bench of this court succinctly articulated purport of an exclusive jurisdiction clause in any contract in the following words. For answer to the above question, my lord, I'm just reading this so that, my lord, I don't have to cite the other judgments. That's the only reason, my lord. For answer to the above question, we have to see the effect of the jurisdiction clause in the agreement, which provides that the agreement shall be subject to jurisdiction of the courts at Calcutta. It is a fact that whilst providing for jurisdiction clause in the agreement, the words like alone, only, exclusive or exclusive jurisdiction have not been used, but this in our view is not decisive and does not make any material difference. Intention of the parties by having clause 18 in the agreement is clear and unambiguous, that the courts at Kolkata shall have jurisdiction, which means that the courts at Calcutta alone shall have jurisdiction. It is so because for construction of jurisdiction clause, like clause 18 in the agreement, the maximum expressio unis exclusio altris comes into the play, as there is nothing to indicate to the contrary. This legal maxim makes that expression of one is the exclusion of another. By making a provision that the agreement is subject to the jurisdiction of courts at Kolkata, parties have impliedly excluded the jurisdiction of other courts. Where the contract specifies the jurisdiction of the courts at a particular place, and such courts have jurisdiction to deal with the matter, we think an inference may be drawn that parties intended to exclude all other courts. A clause like this is not hit by Section 23 of the Contract Act at all. Such clause is neither forbidden by law nor it is against public policy, does not offend Section 28 of the contract in any manner. Then, my lord, paragraph 16 refers to other cases. Then, my lord, 17 says the issue as to how an exclusive jurisdiction clause has to be read and understood is thus no longer res integra. Paragraph 18, bare perusal of the above decision leads to the conclusion that for an exclusive jurisdiction clause to be valid, it should be A, in consonant with Section 20 of the contract, that it should not absolutely restrict any party from initiating legal proceedings pertaining to the contract. B, the court that has been given exclusive jurisdiction must be competent to have such jurisdiction in first place. That is, a court not having jurisdiction as per the statute regime cannot be vested by jurisdiction in the contract. Finally, C, parties must either impliedly or explicitly confer jurisdiction on a specific set of courts. These three limbs criteria have to be mandatorily fulfilled. The 19 swastik gases is wholly inapplicable to the facts of at hand, being a large decision binds us. Then, my lord, kindly come to paragraph 20. 20 onwards, my lord, there was an argument made because, my lord, this was on behalf of an employee that, my lord, it's a unequal bargaining, my lord, and all that. That is, my lord, kindly come to paragraph 22. Nowadays, the private sector employs individuals pan-India for providing services to reach people in the last mile. Therefore, it may not be possible for all employees in the private sector to contest suits at far-off places from the register office. This seems to be the overwhelming reason why exclusion clauses are inserted. Rakesh and Deepthi, having accepted the terms and conditions of the appointment letter, employment agreement, and acted upon in terms by joining their respective posts, they could not have possibly avoided the contract on a second thought that a term contained therein may not be beneficial for them at a subsequent stage. As long as an employment contract does not offend the provisions of any applicable legislation, such as the Contract Act or the CPC, ordinarily there should be no reason to interfere. Cannot but be gainsaid that the scope of interference in such matters is quite narrow. Here, of course, my lord, we are both equal. There's no question of, my lord, one being, my lord, an employee in that situation. The contention on behalf of Rakesh and Deepthi that the decisions referred to above would not be applicable in case of service contract not really impressed us. Contract, be it commercial, insurance, sales, service, etc., is after all a contract. It is a legally binding agreement regardless of the parties involved or their interstate strengths. To make a distinction for employment contracts on the specious ground that a mighty lion and a timid rabbit are the contracting parties would violate the principles of equality in the sense that rights and liabilities would not depend on the party's status, power, or influence. Contracts should not be treated equally without bias or distinction. Fact that one party is more powerful or influential, the mighty lion, and the other more vulnerable, the timid rabbit, does not justify making exceptions or distinctions in the application of contractual principles. I'm just reading this, my lord, not that it at all applies, my lord, to us. তোমার timid rabbit তো কেউ বলতে পারবে না, কেউ বলতে পারবে না। Then, my lord, paragraph 25, then, my lord, 26. Law treats all contracts with equal respect, and unless a contract is proved to suffer from any of the vitiating factors, terms and conditions have to be enforced regardless of the relative strengths and weakness of the parties. And thus, we are unable to approve the law laid down in Vishal Gupta. That was a Delhi High Court, my lord, decision. Then, my lord, kindly come to paragraph 30. My lord, 31 is really, my lord, the lastly, the clause in the contract is clearly and explicitly barred the jurisdiction of all other courts by using the word exclusive. Profitable reference may be made to the extract of the reproduced. So, this is, my lord, the, at least, my lord, we could find, my lord, this is, my lord, one of the latter or, my lord, maybe the last judgment, my lord, on the question of, my lord, ABC. Oh, my lord, in paragraph 33, my lord, my learned friend points out, which is correct. Oh, acha. My lord, kindly look at, my lord, paragraph 33.
Yes.
We hasten to observe the Patna High Court, while correctly holding in favor of HDFC banks, the point of law has committed a fundamental error allowed the application issue and Order 7, Rule 11 of the CPC, meaning thereby plain stands rejected. Since the courts in Mumbai have the jurisdiction to decide the dispute raised by Rakesh and his plaintiff is not otherwise liable to be rejected on attraction under Rule
It should
11.
have been returned instead of
Yes,
rejected.
and that's what we have asked for. Because they have not said that this can only be decided in at the trial stage or at written statement, which is not correct. Because that will not defeat the whole purpose. If you go through trial, then why there's no reason why this court should not exercise jurisdiction.
Then this observation of Order 7, Rule 10 will also not apply.
That's right. That's why, my lord. So Order 7, Rule 10 is where you have to reject the plain. You go there in Bangalore, and we have also anyway instituted, my lord, our suit. Now, my lord, the only other so, my lord, I am not showing, my lord, swastik and ABC laminate, which are both, my lord, quoted here. We had it, my lord, marked out. We'll just, my lord, hand over formal copies if my lord wants to have a look. My lord, those are, my lord, our submission, my lord. Because, my lord, we have shown, my lord, his own cases, my lord, that he's acted upon. In the event, my lord, he wants to make a point on that, my lord, we will then, my lord, answer it. My lord, just, my lord, kindly just come to, my lord, that purchase order once. Just once, my lord.
Yes.
And these are, my lord, it's part of, my lord, all the purchase orders which, my lord, we have given a chart. Clause, my lord, kindly look at clause 23.
Yes, 23.
Jurisdiction, any dispute arising out of in connection with this PO shall be subject. Then 24, PO shall
25.
constitute the entire agreement.
And 25.
Yes, and 25. Supersede, my lord, which there, my lord, there is no written agreement with supersede, my lord, these purchase orders. And my lord, this chart we have given, my lord, on all the pages and all the. Those are, my lord, submissions.
Yes, Mr. Raj.
You want me to start today? Well, I can start well if your lordship wants.
Up to you.
7 minutes left. Do it next day. ভুলতে দেবো না দাদা তুমি
I'm sorry, my lord, I was late, my lord, I just
আমি কিন্তু পড়াশোনা করি ইনস্টিটিউটে
Affidavit in opposition filed on behalf of the plaintiff respondent and affidavit in reply filed on behalf of the defendant applicant is taken on record. Full stop. এটা রয়ে গেছে। There is a supplementary list matter which I'll be taking up thereafter. If side a supplementary which I had fixed.
But I appear for the writ petition as well.
Once this is over, I'll come back to original side again.
But your
I had taken
learned senior
instructions.
friend, Mr. Chatterjee was appearing with the matter.
I had taken instructions. The matter is fixed before DRT on 11. My lord gives them a breathing space of seven days. No, my lord kindly gives them a time for 7 to 10 days max, my lord, because we have already deposited the police cost with the state. My lord, if in the meantime there is a procedure before DRT to file a put-up application, that they may be given a liberty to.
This is on Monday.
On Monday, I'm not taking. On Monday, no.
Kindly direct that, yes, my lord. They will, the DRT will hear it or not.
It will take their application on Monday.
My lord.
Most probably, বোধহয় Monday পারবে না।
Lord, I have for that I have to file a put-up application and reach the learned tribunal, which after which Lordship kindly keeps it on Tuesday or Wednesday, my lord.
হবে না, 2 তারিখ অবধি তো inauguration আছে। 2 তারিখ inauguration আছে, হবে না।
But there is some difficulty.
There is some. The DRAT would be shifting to the that same premises where the inauguration is set to happen on 2nd. And at least till 3rd, my lord has to give them some breathing space, unless my lord gives them that time.
Third, you cannot stay your hand.
Yes, my lord, that I am not saying. But I am saying that he would not be able to list that before 3rd.
No mandatory order required.
Yes. My lord, the only problem is my lord knows that it is not maintainable before this court.
That is why I also cannot pass a mandatory order. That is, if you can say that till 3rd you don't intend to, then in that case that solves the problem.
I was never.
This will create a precedent again.
Yes.
I was never beseeching my lord to take my lord the my lord check the district magistrate's order.
Otherwise, if
My lord, what I
delegating you to the DRT,
my
I'm
lord,
not supposed to pass any order.
I just kindly allow me 2 minutes, my lord. My lord, what has happened is the matter was scheduled to appear in the cause list as a put-up matter yesterday. It was not taken up, which is why I am before my lord. My lord.
This morning.
Yes.
There is a bigger problem which I noticed. I'll show it to you. Come to page 125.
135.
125.
Yes.
First volume, last page.
Nobody appears on behalf of the.
Your interim order got vacated because of your absence.
Yes. Is it, my lord? Yes, my lord.
Therefore, once you have done this.
No, my lord. That was the one solitary instance, my lord, which I did not appear. I filed an application for restoration. My lord, for that also I filed that application. That application is also on record.
Very well. I'll record that bank says that bank is not going to take possession till 3rd.
Till 3rd.
Till 3rd. You take your option.
But my lord, this should not be shown as a precedent for extension of the interim order.
No. That. Nothing
Yes.
more than that.
No.
All the issues may be kept open to be decided by the DRT.
Yes, I'm not deciding anything in any case.
Hey, here. One line at the beginning, my lord, since my lord has directed me to appear on behalf of the bank, my lord, that line.
No, you have taken instructions?
Yes, I have taken instructions.
This matter has been mentioned on the ground of extreme urgency, stating that the bank is intending to take possession of the secured asset on August 29, 2026. On the strength of an order passed by the district magistrate.
District Magistrate Bakura.
The district magistrate Bakura on an application under section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002. Follow. Paragraph.
reassess passed, Lord. In two it was passed on. Yes. I'm giving it today. On 26th of August, the order was passed, my lord. And in respect of three assessment here, where, my lord, in case of two assessment here, there's a refund. One, there's a demand. There are total 7 assessment here involved. In respect of other 4 assessment here, there is some glitch before the CPC, my lord. It will be done. Issue will be resolved, my lord. If your lordship gives us 2 weeks time, if it matters will appear again on 11, my lord. I think, lord, entire thing.
Appear on 11th. In the
Yes,
meantime,
yes.
they will resolve it.
Yes.
Madam, wherever they have processed, they are saying, madam, let them intimate me.
This is the assessment.
I will be happy. Let them intimate.
This is my lord, may I hand it over to your lordship? The instruction which I have had. Yes.
Unless they give it that they have processed, how can I know?
I'm also handing over to him on copy.
That's obvious. Don't be a quarter.
এখানে টোটাল আপনার 7টা অ্যাসেসমেন্ট
আমার 3টে
আপনার না অ্যাসেসমেন্ট ইয়ার হচ্ছে 7 তার মধ্যে একটা মিসিং ছিল
The only thing is whether they have complied it or not. Lordship can see second paragraph Lordship's order. Only.
You see the instructions, you have handed up a copy.
Yes.
You go through this, I'm fixing it on 11th.
Yes.
My Bible, if it is on the 11th, Lordship sees come on the 11th.
Yes.
Well, let it be on the top because after the last matter in the contempt is never called on.
Contempt is not supposed to be taken as the first matter anytime. It is taken up. Today also your matter has been taken up, although it was not called.
No matter. It's suffering for nothing.
Order record for it. Mr. Dudhoria, learned senior standing counsel appearing for the revenue, assisted by Mr. Sharma, learned standing counsel appearing for the revenue. Hands up to court a copy of the instructions forwarded to him.
Your Lordship, I was just humbly praying if your Lordship would kindly keep the matter any day, fixes the matter any.
But presence can be recorded. কেউ আছে নাকি অন্য সাইডে কেউ আছে একবার এই 2 এ রেকর্ড করে দিন কেউ আমরা প্রেজেন্সটা রেকর্ড করে দিই উনি আছেন অনেকক্ষণ আইটেম 2 একটা অর্ডার রেকর্ড করেন আইটেম 2 এ রেকর্ড করে নিন none appears for the petitioner Mr. Banerjee learned senior advocate appearing for the is present for the High Court administration. Full stop. আচ্ছা ওইটুকুই আর কিছু না হ্যাঁ for
My lord, in this matter, my lords, Anjan Bhattacharya is a petitioner, my lord. His clerk is he is in a Bhubaneswar. He is in a Bhubaneswar, your lord.
I have recorded none appears.
Not today, my lord.
Not today only. I have recorded his presence.
I don't like.
With utmost apologies, my lords. My item was item 35. No one appeared for the petitioners. So I asked myself a question, will it come again on next Friday, my lord?
Yes.
Grateful, my lord.
The same list will be recycled on Friday.
Grateful, grateful,
Recycle means barring the matters which have been disposed of.
grateful, my lord.
Thank you.